So what do you
Okay.
remember from yesterday's class regarding interpretation? What is interpretation?
Interpretation means understand the.
Yeah, understand.
You have to understand and you have to translate it now.
Yeah, understanding the true meaning, right? Understanding, translate as in it's not like document is in English, we are translating it to some other language. It's basically understanding, right? We want to understand what is the true meaning of that legislation. So why we need interpretation?
To make law.
We need interpretation for two main things. First of all, a layman may not understand legal language, right? We discussed yesterday. Who is a layman?
Layman, ma'am.
Yeah.
Layman is cap. Um,
Someone who is not having technical knowledge on that particular thing, right? I
yes,
be
ma'am.
a layman for an engineer or a doctor, but doctor or engineer will be a layman for a legislation, right? So whoever is not having technical knowledge, that person is a layman. So we need to interpret, to understand the true meaning. Why? So that a layman can also understand what the law is, right? Because in first semester, you are finding it difficult to understand these legal terms, right? That means what?
Yes,
Now you are a layman for legal language also, but as you
yes.
start with your LLB course, you will become expert in those technical words, right? So layman is a person who do not know those technical words, so for them, we need to interpret, right? So that they also understand it. And second one is legislative intent. We have the legislation, but we want to understand with what intention this legislation was introduced, right? So these are the two main reasons why we need interpretation of statute.
Okay.
So what are the rules of interpretation?
Legislation, executive, and judiciary.
Those are organs of government, right? There are three organs: executive, legislature, and judiciary. So who will interpret legislation? Which organ will interpret legislation?
Legislation, executive, ma'am.
Not executive. So legislation will give the law, executive will pass some orders, notifications, etc., and judiciary will interpret, right? Because judiciary will give punishment, so they need to understand what the law is, and then only they can apply, right? So you can remember this definition as well regarding interpretation. Now we need to understand rules of interpretation. What is rules of interpretation, right? Interpretation means what? Understanding true meaning. Fine, we need to understand the true meaning. But how will you understand the true meaning? Right? Like you want to read this legal method subject. Maybe you are attending your college classes. Maybe you are doing some extra classes. Maybe you are reading it yourself. Right? Maybe you are referring some guidebook. That means you can follow different rules to understand this subject. Similarly, judges can also use different ways of interpreting, right? By different ways, they can try to understand what is the true meaning. So there are basically four important rules of interpretation that you need to remember. Okay, so you know why we need interpretation. Interpretation means understanding true meaning of the legislation, right? Why we need interpretation? So that even a layman can understand it, and we are able to understand intention of legislation, why this legislation was introduced, right? Now four rules are there that will be applied, right? Basically they tell about four different ways of understanding the true meaning. Okay, so what are these four rules? One is literal or grammatical rule. Second is mischief rule. Third is golden rule. Next one is harmonious construction rule. Okay, so we have four different rules of interpretation that you need to understand. And I'm almost sure there will be a question with regard to this in your exam, right? So maybe you can remember this, and if they ask a question, you can write rules of interpretation. You can put 4 arrows and then mention these 4 different rules also, and then accordingly explain one by one.
Okay.
Now, this table will help you understand what these rules are basically, but again, we have discussed in detail also. All right. So first one is literal or grammatical rule. Okay, so if you are saying something, we often use, right? Like literally, I was shocked. What is literally? That means exactly like I was really shocked, right? You use this word, right? When you are saying something like literally it happened. That means what? It exactly this only happened. So same literal or grammatical rule. What they will do is that the ordinary, natural, or popular or literal meaning of the words has to be taken into consideration. Okay, if there is a provision, whatever is written there, right, that we will understand. I will just give you one example. Take for example, no person shall be deprived of his right to life and personal liberty. There is a provision under constitution. All right, it is a provision under constitution, article 21. Okay, article 21 of Indian constitution says, this is only an example. Okay, you don't need to write
Okay.
this in exam for your understanding. Take for example, there is a provision, article 21 of Indian constitution. What is written there? It is written, no person shall be deprived of his right to life and personal liberty. Okay, so now if we want to interpret this thing, if we want to understand what they meant by it, we will look at the ordinary meaning of these words, right? Normally what we understand by person, we understand men, women, or any other gender also, right? So same meaning we will give here. No person, that means it may be a citizen also, it may be a foreigner also, it may be men, women, any other gender also, right? We will give that meaning. Shall be deprived. What is deprived? You are not given something, right? That means no person shall be deprived of his right to life. What is life? Survival, right?
All
Like,
right.
yeah, survival, right? So we will understand the, okay, fine, survival. And personal liberty. What is personal liberty? The person should be free, maybe to speak, maybe to start a vocation, maybe to go anywhere, right? So we will accordingly understand. So in literal or grammatical rule, we will understand what is the popular meaning of those words, right? Popular meaning as in commonly what we use, right? Ordinary or popular, that means ordinarily, by no person we do not just restrict to Indian citizens, but it will be any person, right? Any person, whatever gender, whatever age, does not matter. No person means just any person will be included there. Deprived as in not giving, right to life as in the person should not be killed, and the person should be allowed basic liberty or basic freedoms. All right, so we will understand ki, okay, fine, under literal rule we will try to give those common or popular meaning to each and every word, and then we will try to understand what this provision is basically. Is it clear?
Okay. Yes, ma'am.
All right, next one is mischief rule. Now, mischief rule finds out the defect. What is mischief basically is some kind of a defect. All right, like if you are destroy, like strike, you understand, right? People protest, there will be strike.
Yes.
Okay, in strike, take for example, you are protesting against your university. All right, in protest, if you try to destroy your university or college property, that will be mischief, as in you are destroying or you are causing some defect or destruction to university property. That means you have committed mischief. Okay, so mischief basically means some defect, some fault, right? So mischief rule tries to do what? It finds out mischief or defect in the statute. All right, whatever statute we have, it will try to see what are the defects in the statute and then provides remedy for the same. It closes loopholes in the law and develops new law. New law. That means it tries to fix whatever defects are there in the existing law. All right. So we will see examples also. You will understand this better. Take for example, here what happens? Same example we will take, all right. A provision is that no person shall be deprived of his life and personal liberty. Now, under personal liberty, they are just saying that, yeah, you should be able to eat, you should have a shelter, and what is the other one? You should have clothes to wear. That's all personal liberty means. Okay. Now we feel that no, these three are not the only personal liberty that we need. We also need freedom to speech, right? So in mischief rule, what they will do, they will say that personal liberty is a word. We usually understand it to be food, clothing, and shelter, but it should also include right to speak, right? That means mischief rule tries to find out the defect. What is the defect? This provision is there, but it is not giving us liberty to speak, right? So it will try to fix that. It will say personal liberty also includes right to speech, right? So by applying this only, we have interpreted Article 21 so many times. Now it includes right to go to right to travel abroad, right to privacy, right to education, right to livelihood, right? So all those are included. How? By finding out the defect that we have under Article 21. Is it clear?
Yes, ma'am.
Are you able to relate, or you are finding it like too philosophical or something? Is it
No, no,
relatable?
ma'am. I'm understood. Yes, ma'am.
Understood, right? Okay, fine. So literal as in whatever is the ordinary or popular meaning, you give those meanings to each and every word and then finally come to a conclusion. Mischief as in mischief means defect. So you try to figure out what is defect in that existing legislation and you try to close those loopholes. How you will close it? By interpreting. You will say personal liberty also includes right to speech, right? So that is mischief rule. Third one is golden rule. If considering natural meaning of the words lead to injustice, courts must modify meaning to remove injustice. Now, here what we are doing, we are giving meaning to each and every word, right? Each and every word we are giving meaning. But after, like these are individual words, right? We gave meaning to each and every word, and finally we see that this is not making much sense, right? This is not giving justice to people. In that case, what we will do is we will try to fix it in such a way that this injustice can be removed, all right? And it will make some sense based on the purpose why that legislation was made. Okay, if we are giving meaning to each and every word and then find out that this is making no sense or maybe it will be injustice, we will try to modify this a little bit based on the object why this legislation was introduced. Is it clear?
Yes, ma'am.
So that is why it is called as golden rule, because it will solve all the problems, right? It's like the best rule because we have the option of modifying it a little bit based on the object of that particular legislation. All right, is it clear?
Yes, ma'am.
Next one is harmonious construction rule. So harmonious construction, it can be understood from the name also. What is harmony? It's like harmony, right? How you can have harmony when two things are properly there in place, right? It's not conflicting or something. That's harmony. Harmonious construction rule. That means you should construct provisions in such a way that there is harmony between two different provisions, right? Two different provisions are not conflicting or contradictory to each other. They should exist at the same time harmoniously without conflicting with each other. All right, that is harmonious construction rule. Applied when there is a conflict between two or more statutes or between two provisions of the same statute. It may be one legislation is there, like Indian Constitution, but there are two provisions which are like conflicting, right? Take for example, you are saying that I have my exams from 16th of March, but I'm saying no, you don't have your exams from 16th of March, you have from 16th of some April. In that case, what happens? We both are giving conflicting statement, right? So what this rule will do is that it will try to balance both the things. Okay, it will say, okay, fine, you have one subject on 16th of March and another subject on 16th of April. That means what? You are also true, I am also true, right? Harmoniously, we both are existing and there is no conflict between us, right? So that is what harmonious construction is, that with harmony, both of you exist, all right? You should not conflict with each other. It may be two provisions of a same statute or it may be two different statutes.
Okay.
Okay, so can you tell now what are these different rules? What is literal or grammatical rule?
Literal rule, actually, harmony rule means it will balance both the sides, ma'am. Because you are right and I am also right.
Then?
It will pass the statement. Passes the statement.
What?
It passes the statement.
Okay, so it will balance both the two provisions. Yeah, and?
Yes. And golden rule, it says.
What is literal or grammatical rule? First one.
It will say right to life. We have to right to life, and
that is just an
Article
example. That is just an example. You can just say what you will do in case of literal or grammatical rule. Whatever popular or common meaning is there, right? We will give those meaning to each and every word. If there is a provision, we will try to give common or popular meaning to each and every word and then finally come to a conclusion. Okay? Use common or popular meaning of each and every word and then finally come to a conclusion. What is mischief rule?
Ma'am, sorry, popular and conclusive.
Popular and common, right? Whatever is very common, whatever is very popular, that we will give. What is mischief?
We have, we won't give popular and common.
Yeah, what we will do then? What mischief means?
Mischief means some kind of a defect.
Yeah, so what you will do in case of mischief rule?
Well,
whatever defect is there, you will try to fix it, right? If mischief means defect, whatever defect is there in the legislation, you will try to fix it, okay, by interpreting it in such a way. All right, what is golden rule? Golden rule means
mischief rule, we have to, whatever defect is there, we have to
fix it.
There is a legislation. We have to fix it.
Yeah. Whatever defect is there in a legislation or in a provision, you will fix it by interpreting it in such a way. What is golden rule? Hello?
Yes, ma'am.
Yeah, so golden rule means
Po-
what? When you are
Positive
give,
or negative, positive and negative interjection governing conduct, ma'am.
okay. So
No.
when you are giving literal meaning, right? When you are giving ordinary or popular meaning to all the words, but then you find out that this is not making much sense, or it is giving injustice, right? It will be injustice or inconvenience. Then you try to interpret it in such a way that all these injustice and inconvenience can be removed, right? So in golden rule, you try to remove injustice. From where this injustice is coming? By giving ordinary or popular meaning to all the words. Whatever injustice is being created, that you will remove. All right, so these are the 4 different rules of interpretation that we have. We will see in detail also, okay? In that case, it will be much clearer. So this is literal or grammatical rule. This is the first rule of interpretation. According to this rule, the words used in text are to be given or interpreted in their natural or ordinary meaning. Whatever ordinary meaning is there, that only you try to give and then accordingly understand. According to this rule, the only duty of court is to give effect if the language of the statute is plain and has no business to look at consequences which might arise. So you basically simply give the meaning, popular meaning to the words, and then you try to understand what this is. Okay, so there was one case where what happened is a person was caught along with counterfeit currency dollars, all right, fake dollars, and he was charged under provisions of Indian Penal Code. So Indian Penal Code basically provides punishment if you are having fake currency notes, but Indian Penal Code do not so Indian Penal Code has not specified whether it will include foreign currency notes or not, because dollars is foreign currency, right? So whether it includes foreign currency or not, that is not specified under IPC. So court held that the word currency note or bank note cannot be prefixed, the person will be liable. That means the person was held liable even though he was having false currency dollars. All right, why? Because we have just mentioned currency note, we have not mentioned Indian currency notes or something like that. That is the reason why it was included. Basically, what is currency note? Any country, it can be of any country, right? So simply they understood currency note may be of any country, so simply make the person liable.
Okay.
Okay, so you do not
What you
see
underline? What you
this.
underlined is the case.
Yeah,
This
this is the
case, ma'am.
case. Yeah. So do you find it difficult to remember this part, or is it fine for you? This much?
I'll remember it, ma'am.
You will remember, right? So in notes, right, I will put this also, because I am like almost 90% sure there will be a question from interpretation. You can put this also, okay? I will not give this much big for you. Just in 1 or 2 sentences, I will try to sum it up and you can just remember this. Okay, you can remember. So literal or grammatical rule basically means whatever true meaning is there or common or popular meaning, you give that meaning and then you accordingly try to understand it. All right.
Okay.
Next is mischief rule. What happens in case of mischief rule? We try to understand whatever problems are
Whatever
there.
defect is there, whatever
Yeah.
defect is there, we have to in legislation we have to
Hmm.
fix it by interpreting
Yes.
it, ma'am.
Yes, we need to interpret it accordingly. So there was one case also, it's a foreign case, where what happened is that there were prostitutes who were soliciting in the streets of London. And it was creating a very big problem in London. All right. So what they did is they were having a legislation called Street Offences Act. That means whatever offences you are committing in streets, with regard to that, this legislation was. So under this legislation, whatever crime you are committing in at a street, you can be held liable. So just because they were having this legislation, what was done is that case was filed against those prostitutes and they were held liable. All right, so they were held liable under this legislation. Prostitutes started soliciting, and after that, what they did is they started soliciting from windows. All right, windows or from their balconies. Again, case was filed, but they said that we are not committing any offense at the street, right? So we cannot be held liable. We are doing it from our windows or balconies. So in this case, court applied this mischief rule and they said that there is a defect in this legislation, Street Offences Act, because it is just including whatever is committed at the street, but it should also include those soliciting from windows or balconies. So they applied mischief rule and said that these prostitutes will be held liable even though they are soliciting from windows or balconies. All right, that means what? We are having this legislation, Street Offences Act, but this legislation was not sufficient to deal with the problem. Right? There was a defect. That defect court tried to fix by interpreting it in such a way that it will include even though a prostitute is trying to solicit from windows or balconies. All right, is this part clear? Like, we have a legislation, but it's basically not serving the purpose, right? So you accordingly interpret it so that it serves the purpose. All right, so for 4 different rules, you just need to remember this much. Is it possible?
Yes, ma'am.
Possible, right? So I will just write this in 2 or 3 sentences and you can accordingly remember the case law. Okay, when I share the document with you, I will do that.
Ma'am, this I have to only read, no, ma'am?
Read as it? Yeah, just to understand. You don't need to write this much. I will make it short for you.
For functions of law also, prepare notes, ma'am?
Yeah, functions of law also I'll prepare.
Okay.
Yeah. So for now, I just told you that you try to remember the headings for all the different 14 things. Yes. You can do that. You can remember, okay, fine, there are 4 different rules of interpretation. Definition part you can remember. Otherwise, I'll just make it short so that you can directly read from there. Because obviously it's not possible to write this much, right? So I'll do that. Okay. What is golden rule? When you are interpreting by way of the grammatical or literal rule, you are giving true meaning of each and every word. It may be, what happens is, it may lead to injustice, right? It may not make much sense when you interpret the legislation. At that time, you will apply golden rule to solve all those problems that has arisen because of the grammatical rule. All right, so literal rule follows the concept of interpreting the natural meaning of words. But if doing so, there is any kind of problem, then court will modify the meaning and in order to remove those injustice or problem that may be there. All right. Okay. So there was one legislation where it was said that there is basically a time limit fixed when you can appeal. That is 6 months when order is being passed. So court said, okay, fine, it's 6 months within which you need to approach the court and file an appeal. But later on, it was said that 6 months is not the proper time, but appeal was filed beyond 6 months and appeal was rejected. So court said that this period of 6 months should be counted from time when this person came to know, because interpretation was leading to, it was not properly solving the purpose, right? So we should not give literal meaning to the words. Whenever needed, we should try to fix those defects that has been created because of interpreting under literal rule. Okay, I'll give the cases in 1 or 2 sentences. Okay. And last one is harmonious construction, where we basically try that 2 provisions of a same statute will coexist or 2 legislations will coexist. It happened with regard to this case, MSM Sharma versus Sri Krishna Sinha. What happened here is there were 2 provisions of constitution which were conflicting with each other and court tried to balance that out. right? Court basically said that one provision is superior, another one is inferior, but they both will exist at the same time. So accordingly, I'll give for this one also. No worries about that. You can remember this part, okay? Then you can write one conclusion, all right, that everyday working of courts involves interpretation of statutes because it is duty of judiciary to act according to the true intention of legislature, right? When a law is passed from legislation, judiciary should ensure ki, okay, fine, this is why this law is brought, and accordingly they should try to serve that purpose. So statutes are to be interpreted to enforce the law and also to avoid miscarriage of justice, right? Why law is there? We studied in our first class. It is to provide justice.
It is to, yes, ma'am.
Provide justice, right? So if law is not providing justice, it will be of no use, right? So we will have to interpret it in such a way that it is providing us justice, okay? And it is not leading to injustice of any kind. But if in interpretation or the result is injustice, some kind of inconvenience or problem, it should be avoided, and the one which supports justice, right? In whatever way you can, you try to provide justice to the people. That is why we have different rules, so that based on the situation, that rule can be applied and justice may be provided. Why? Because ultimate aim of law is to provide justice only. Is this part clear?
Yes, ma'am.
Okay. So do you need this entire document, or you want me to like frame proper answers for you so that you can directly read from there?
I'll directly, but to understand, I have to know, ma'am. Tomorrow, if you'll ask questions, I have to read, ma'am.
So how I will give you the entire document, or I will just frame the answer and give it to you?
Today only you'll frame, ma'am.
Yeah.
At last you'll frame.
Yeah, today I can send.
Or else do tell all the syllabus and send me answers at last, ma'am.
Okay, okay, fine then. So I can do one thing also, right? For this part, right? I can send it to you today so that you can start preparing also at the same time. And whenever we are doing whatever things, I will, like keep sending you so that you don't wait for the last time, right? So this part I will share so that you can start preparing at least these two questions. What is meant by interpretation of statutes and rules of interpretation? Okay, because this is like very important and I feel there will be questions from this part.
Okay, ma'am.
Then precedent, are you clear with this?
Precedent, ratio, dissentee, obiter dicta. Okay, ma'am, no problem.
You know, right?
Yeah, I know. And also, Sardis something is there, no, madam?
What is?
One more is there, no, madam? Ratio, dissentee, obiter dicta.
Stare decisis is there.
One more, madam. What is it?
Stare decisis.
Stare decisis.
Types of precedent.
Types of precedent. Can you just explain to me, ma'am?
Okay. So what is precedent basically?
Precedent means, madam, that is the higher court. No, whatever the higher court is given, we have to follow the lower court. No, madam, that is precedence. No, madam.
Yeah. So previously decided judgment of higher court will be binding on lower courts. Whatever Supreme Court said, it will be binding on all courts in India. Whatever High Court said, it will be binding on lower courts under that High Court, and for other High Courts, it will be like persuasive nature. If you want to follow, you can follow. If not, also it's fine. It's not binding on you. All right. So that is basically precedent. Now there are different kinds of precedent which we have. Okay. First is original and declaratory. Okay, these are like two different kinds because they are related. I put it in one single thing. So first is original and declaratory. Second is authoritative and persuasive. What is original and declaratory? Original precedent is where judges create a new law and the same becomes binding. All right, a new law becomes binding. That means we do not have a law or legislation on a certain area or matter, and judges have given us a law with regard to that, and it becomes binding. Take for example in India, who is a witness, by the way? Witness?
Madam,
Who is a witness?
witness is the judge himself, no, madam,
Uh,
or legislature.
no, witness, you must have seen, right? I was an eyewitness of it. Witnesses need
Okay.
some document. Who is witness?
Yeah. The person who was seen.
Yeah, who has seen the thing, right? So if, for example, I have committed the offense of kidnapping or maybe murder, and you are a witness, you have seen me committing the crime, what you will do, you will go before court and say that yes, she has committed this offense, I have seen this myself, eyewitness. Okay, so when I know that you are a witness and you have seen me committing the crime, and you will go before court and tell the entire story, I may try to harm, or I may try to put you under some sort of a fear or threat, okay, so that you do not disclose those things before court. All right, so it's important that you are being given some sort of a protection, so that I cannot do any harm, and you can appear in the court as a witness, tell whatever you know, right? So we were not having any legislation with regard to protection of witnesses. That is the reason Supreme Court introduced something called as Witness Protection Scheme 2018, and it is binding entire India. So what is that? It is original precedent. Before this decision, we were not having any legislation or anything with regard to protection of witnesses, but this new concept was introduced by Supreme Court in a decision. So that decision becomes what? It becomes original precedent, right? That means a new law is introduced by court in this particular decision, and it is made binding in India. Okay, that is original precedent. Something was not existing, court gave it. It's original thing that court has given. Is it clear?
Clear, ma'am.
Okay. Second one is
that is. Sorry, ma'am.
Yeah.
The witness protection scheme was the president of that 2018.
Witness protection scheme 2018 is basically a scheme. The decision that Supreme Court introduced it in a court's decision, that is a precedent. Okay, precedent basically decision of a court.
Okay, understood, ma'am.
Okay. Yeah. So what is declaratory? What is to declare? Meaning of declaration?
Declare means declare the precedence means the old precedents may be shown or something. Judge can speak there only, madam. Declare his opinion.
Declare means, yeah, declare his opinion or something, right? Declare means to say something very frankly, clearly, right? So when I say declaratory precedent, what happens here is, yeah, what is declaratory precedent? Declaratory precedent is where a known or established law is applied to a particular case. That means law is already there, but I am again declaring it. I am again saying it very clearly. Okay, take for example, under Constitution, we have a provision called Article 21, which says that we have a right to life and personal liberty. That means I have a right to be alive and enjoy personal liberty. Now, it's not very clear what is personal liberty, right? What is to life? Is it just food, clothing, and shelter? Is it just a right to be alive, or what is it? So Supreme Court in different cases have included different things to be part of Article 21. They said that to be able to enjoy our rights, we need right to privacy, right to travel abroad, right to livelihood, right to clean air, right to education, all this stuff also we need. So what is that? It is declaratory precedent. Article 21 was already there, but Supreme Court has clearly declared that it also includes right to privacy, right to travel abroad, right to clean air, right to education and all these other stuff, right? So all those decisions will be what? Nothing but declaratory precedent, where 21 article 1 was already existing. Supreme Court has declared it very clearly ki it involves all these other things also. Okay.
Okay, ma'am.
Is it clear the difference between original and declaratory?
Yes, ma'am. Original and okay, understood, ma'am.
Right. So original is not there. It is not. It was not existing, or like for the first.
Making a new law, making a new law.
Yes.
Making a new thing.
Making a
Declarative means adding something to the which was already there.
Yeah, adding something or something like that, right? That you are basically declaring it. It was already existing there. You are once again just declaring it very clearly. Yeah, it is what the provision is. All right. So next category which we have is, this is the first category of precedents, right? Which we have, original and declaratory. Second is authoritative and persuasive. What is authority? What is authority?
Authority means commanding, no, madam. He has authority to tell this is what to be done.
Yes, that authority is like commanding. Your
Commanding.
Yeah, university has authority over your college. If your university is saying from 15th to 23rd we are going to conduct exams, your college will have to abide by that. Why? Because university is having authority. Similar, authoritative precedent means what? Whatever is said, whatever is declared, whether it's original or declaratory, you need to follow it. Why? Because it is like a command, or it is having authority. If Supreme Court has said something, all the courts in India will have to abide by that. Why? Because it is authoritative precedent. Supreme Court is like topmost court. All the other courts coming under it will have to abide by that precedent, right? Lower courts would have no other option. So that is authoritative precedent. What is persuasive?
Perseverance, I don't know, ma'am.
Persuasive is like, take for example, if your college teacher says something, all right, that for legal methods, interpretation of statute is very important. You will believe the teacher, right? You would feel ki, okay, fine, actually interpretation of statute is important. Why? Because your teacher is having authority, right? So you would believe. But if your friend comes and tells you that interpretation of statute is very important, in that case, you would feel like, yeah, okay, maybe it's important. All right. Why? Because you and your friend is same, right? So you would not have that much, not feel like his statement is having that much of authority, right? That means what? It is persuasive. If you want, you would believe your friend. If not, you would not believe. So that is nothing but persuasive. That means that thing may be there in back of your mind. You may feel ki, oh, okay, fine, my friend told interpretation is important, so maybe I should read this also. But if your teacher, it's like authoritative, you will for sure read it properly. When your friend says, it's like persuasive. Okay. So what is persuasive precedent? Persuasive precedents are those which the courts are not bound to follow. You are not bound to follow what your friend is saying, but you may consider it, right? Why you may consider it? You may feel ki, okay, fine, this friend of mine is a very serious student. Maybe whatever he is saying is right only. Maybe I should study interpretation. So you may follow it or you may not follow it. That is what is persuasive precedent. Okay, take for example, you are judge of Karnataka High Court and I am judge Punjab High Court. Whatever decision you have given, you are not bound to follow that. But you may feel that you find this decision is making sense. Maybe I can refer that decision. All right, that is persuasive. You may refer that your decision may be slightly influenced by it, but it is not binding on you.
Okay, understood, ma'am.
So see, these are the 4 different kinds of precedent: original, declaratory, authoritative, persuasive. Original is new thing you are declaring for the first time. Declaratory was already existing, you are just making it very clear and declaring it or adding certain things. Authoritative precedent is for sure you will have to follow it, it is having authority. Persuasive as in you can follow or you may not follow also. Okay. Now,
Okay, ma'am.
authoritative precedent is again divided into 2 subheadings: absolute authoritative, conditional authoritative. Do you want me to explain this or is it too much?
It's okay, ma'am. Please explain to me.
Okay. So for all these other 3 types, right, it's just one only. For authoritative only, we have 2 different like sub points. All right. So what are these? We will see. Authoritative precedent means it is having binding force. Now, absolute authoritative precedent and conditional authoritative precedent. What is absolute and what is conditional? What is condition?
Conditions means, ma'am, court may put some conditions according to the situations. Seeing the condition, court may give some verdicts, ma'am.
So absolute authoritative precedent means it is absolutely binding. You don't have any other option. You will have to follow it. Conditional authoritative precedent means under certain conditions it is binding. Under certain conditions it may not be binding. All right. Take for example, Supreme Court of India has passed some decision. That decision will be absolute authoritative precedent for all the other lower courts, right? High courts, court, magistrate court, municipal court, every other court have to abide by whatever Supreme Court has. So that is nothing but absolute authoritative precedent. You don't have any other option but to follow it. Conditional authoritative precedent. That means under certain conditions they are binding, under certain conditions they are not binding. Okay. So there is like a thing, take for example, someone has filed a case before Supreme Court. Okay. How many judges have decided the case? Is it 1 judge? Is it 3 judges, 5 judges, 7 judges, 9 judges, 11, 13? How many judges were there? Okay. Based on that, authority will depend. Okay. If take a group of 9 judges has given a decision, all right, that decision will be binding on any other matter which is decided by less than 9 judges. Okay, that is authoritative precedent. But if 9 judges bench has given a decision and a 13 judges bench is deciding a matter, they are not bound to follow it. That means it becomes conditional authoritative precedent.
Conditional authoritative. Okay, understood, ma'am.
If less number of judges are deciding, it will be binding. If higher number of judges are deciding, it will not be binding. That means there is a condition. Based on number of judges, we will see whether it's binding or not. But this will happen only for Supreme Court. Okay, whatever number of judges are there in High Court, that does not matter. They are bound by decision of Supreme Court. But when
like talaq, for example, the talaq, you know, three to five, 3 judges gave that talaq, no, madam?
Yeah. So that will be binding. If Supreme Court is giving, courts will be bound. All the lower courts would be bound. But Supreme Court, high number of judges can change that decision also. Right? That is authoritative.
Okay, ma'am.
All right. So you can simply remember this particular table. Otherwise, what is it? It is very understood from the name itself.
Hello?
Yeah, hello. Is it audible?
Yeah, now it's audible, ma'am.
Okay. So I was saying that you can simply remember this particular like diagram thing. Otherwise, from the name itself, you will be able to remember, right? What is original, declaratory, authoritative, persuasive, absolute authoritative, conditional authoritative. You can simply remember this chart. And if there is a question on kinds of precedent, maybe you can even draw this particular diagram so that again it becomes very like evident, right? That it's very clear to you. Okay, fine, 4 kinds, and then there are again 2 subheadings. So you can put sort of diagrams also.
Okay, ma'am.
So did you see that in your syllabus there is one topic on precedent? Seen that word? I guess some unit 4th or something.
I don't know, ma'am. Just a second.
Wait, I have the syllabus. I'll open it. Okay, so this one, unit, your module 3. Okay, identifying law in judgments. So what is a judgment?
Which is passed by any court.
Yeah.
Or any.
Yeah. Passed by a court. It might be a body which is similar to a court, like a tribunal, commission, like that also. So identifying law in judgment, that means in a judgment also there can be a law. Okay, otherwise what we see in a judgment, it's like court would try to provide justice to a parties, right? Court may impose some punishment, some penalty, compensation. That is the common understanding. But then in a judgment also there can be a law hidden there. So what can be a law which is there in a judgment? Anything that you can think of?
No, I don't know. I think the judgment passed by the judges can be law.
But then what judges are saying? Judges are simply saying there is already a legislation. This is the punishment given. So based on that, we are giving this punishment to the accused person or to the convicted person. That is what they are saying. But then what is law in a judgment? Because judges are also ultimately referring to the law, right? The legislation, the statutes which we have. But then what is law in judgment?
Yeah, I don't know.
We discussed this, right? Common law countries and civil law
yes,
countries. So what judges will do there in common law countries?
I think they pass their judgment.
They do pass the judgment, but there's sometimes what happens, right? Even though we have a written legislation, or like in India, if you take the example, we have thousands of legislations talking about different areas, but still there may be one area where we still don't have a law, or might be there is an area where even though we have a law, it's not properly addressing the issue. There what courts can do is, while giving a judgment, right, while deciding on a certain case, court may say that on this certain issue we still don't have like a proper law, and that's why we are giving this guidelines, we are passing these guidelines which will be binding just like a law passed by legislature. All right, that means in a judgment courts can provide list of guidelines which need to be followed, and those guidelines would work just as equivalent to as like a law, regular law that we have. Okay, like if you talk about such laws, there is one famous case, D.K. Basu case, where list of guidelines were provided, list of rights were being given to prisoners, and those are followed even now. There was one case again, Hussein Nara Khatun, where also few things were said. There was a judgment wherein court said that witness protection scheme, court basically validated it, and court said unless and until we have like a specific law, this witness protection scheme will be applicable, and that's even applicable now. That means those are nothing but law in a judgment. While deciding on a certain case, court mentioned something which became like a law, which became applicable just like a law. Okay, so today we are going to study judicial precedent as a source of law, because if you see this module 3 from your syllabus, there it also talks about precedent. Now, what is precedent? Judgment you already understood. while deciding on a certain case, what court says, that's nothing but judgment. But then what is precedent? Have you heard this word before?
I think it's similar to preceding one, like this.
Preceding one. Okay. So precedent basically means that whatever judicial decisions are given, right, whatever judgments come, it's not like this judgment is valid only for that given case. Only in order to provide justice in that case, we would refer that judgment. After that, it's of no use. It's not like that. Judgment will be valid even afterwards. How is it valid? Because when, take for example, if you decide to start your practice after completing LLB, when you are going before court representing a client, and you are saying that my client should be getting this, should be getting that, you cannot simply make a statement. Your statement should be supported by some judgments also. There it becomes relevant. Okay, you will look at previous decisions where court has given a judgment in favor of that certain person. You will refer those judgments and you will appear before court. That means to give strength to your arguments, you will use those judgments. Similarly, courts will also try to take help of previously decided judgments. Okay, so that concept is called as precedent. That means previously decided cases or judgments or decisions are binding on whatever decisions are to come. And that concept is nothing but precedent. Now we'll understand it clearly. In simple words, judicial precedent refers to previously decided judgments. All right, it is previously decided judgments. It might be a case which was decided in 1950, 1940, 1980, whatever it is. That can be considered as precedent. That means it is previously decided judgment. But of which court? Is it like any random court? Is it like a city civil court? Is it like a municipal court? Which court is it? It is of superior courts. That means of High Court and Supreme Court that we are referring to. Okay. Previously decided judgments of superior courts like Supreme Court and High Court, which judges are bound to follow. That means whatever higher courts have already decided, it's like a set law it would apply. Once they have used their brain, decided on the matter, taking a lot of their time and effort, same task you don't need to repeat in every single case, because similar cases are going to come before court. Every single case, every single time, you need not waste your time. If something is already decided and there is no problem in that decision, you can simply follow it to give decisions in the subsequent cases. If there is a problem, definitely you can make changes there. No problem. But when something is already decided, let's take that as a set law and just try to follow it. And that concept is nothing but precedent, that we follow whatever is already decided by the higher courts. And this binding character of previously decided cases is important considering hierarchy of courts established by legal system of a particular country. And India also, we have a certain hierarchy of court, right? What is the hierarchy of courts in India?
District, High, and Supreme Court.
So which one is highest court?
Supreme Court.
After that?
High Court and then District Court.
After that, district courts. Right. So we have a certain set hierarchy of courts. That means we have Supreme Court topmost. After that, high courts. These are superior courts. And below that, all the subordinate courts come. And that hierarchy is given in Constitution of India. And Constitution of India is considered as supreme law of land. It's like on top of everything. And if Constitution has said that Supreme Court is highest court, apex court, and below that all the 25 high courts are coming, then we need to respect that. And that is why whatever they are saying, that thing will be binding on the lower courts. All the subordinate courts, it will be binding. Okay. Now, this concept is called as that. Okay, judicial decision, you understood what is judicial decision. But now, in a judicial decision, there will be two different parts involved. Okay, when parties go before court and claim their rights, there will be two different parts in the judgment. Take, for example, there is a case wherein it's a case of child labor. Okay, a child is being employed as a worker in certain industry, so it's a case of child labor. The matter went before court. Now, when court will give decision, right, there may be two different parts involved in the judgment. First one being reason decision or ratio decidendi. Okay, what is reason decision now? Just because someone is appointed as a judge does not mean he can do whatever he likes. Okay, the person cannot be like, okay, what is the matter? Oh, child labor, this is the punishment, take it. That will not happen. Even though someone is a judge, that person needs to hear both the sides and properly give a decision. When a decision is being given, some fine, penalty, imprisonment, whatever is the punishment, judge needs to justify his punishment also. Okay, whatever is the punishment or compensation, whatever he has said, right, he need to justify it also. Judge would say that, okay, like child labor is a very serious crime, we have this law, that law, that law talking about it, and these are the punishments. So in this certain case, these are the laws applicable, and based on this, that, so and so decision, this decision, that decision, we have decided to give this punishment to the person. That means it's not just simply he has said that this is the punishment, take it and go. No, he will justify the decision also. That means reason of decision, why that certain decision is given. For that, judge will mention a reason, and that is nothing but ratio decidendi. Okay, that's the first part of the judgment. And this is the most important part. When we say precedent, we mostly refer to this part only, which is binding. If next time similar situation comes before a lower court, they will refer this decision. That in so and so case, High Court had said like this, or Supreme Court had said like this, so we are going to follow it. That is nothing but ratio decidendi. And that's why it's so important to be updated with landmark decisions. Because whatever courts are saying, that is becoming like a precedent. Other courts will have to follow it. Okay, that's the first part. Is it clear?
Yes, ma'am. Ma'am, I have one question. Like, is it same for all type of courts? Like district court judge can also, I mean, like judicial decision in district court is also same as like this process.
We are coming to that also. Okay,
Okay.
we have that part. What is binding on whom? We'll come to that also. So first part we have is reason decision. You need to give a reason. You need to justify why you are giving that decision. Secondly, there may be some general observations which are made by judges. That means while deciding on that case, while hearing the stories and everything, judge may put some comments, right? Like even if your friend is telling you a story, you would always comment, right? Oh, this is very bad. This should not happen. And you know why this is happening? It's because of that reason. That means you are giving your opinions there, even though your friend was telling you a story. So like that, even judges may put their observations forward, right? When they are deciding a case on child labor, they may say that child labor is increasing too much, maybe because this free and compulsory primary education which is being given, maybe that's not enough. Maybe we need to provide this also, that also. Like that they can say. Those are not laws as such, but those are observations made by judges. As such, like a precedent, it's not binding, but yes, it's not like these observations are completely useless. They also have some importance. Like if legislation wants to make a law, they can refer to these observations that in so and so case, judges said that this law on free and compulsory primary education is not sufficient. So maybe we should make some changes. We need to bring some amendments. That means this observations made by judges has helped in a way the legislature to realize what all changes they need to bring in a given legislation. Okay, so it's not as such directly binding or something, but it may have some value still. And this part is called as obiter dicta. But when we talk about precedent, we basically refer to this part, ratio decidenty. And these two words or this division, right, you need to remember it anyhow. It's very important. Okay, this part is clear, right?
Yes, ma'am. Observation can be like can it be general observation, or like always it is legal observation?
No, not always legal observation. Sometimes it can be general observation also. That just an example, okay? Court may say that why is child labor increasing? Because even though government has provided free and compulsory education, might be parents or guardians are not willing or ready to send their kids to school. Because if they are not going to school, they can do some labor, earn few rupees. Maybe parents are only not interested to send their kids. So that observation would also have value, and maybe the parliament can feel like maybe we need to impose it as an obligation, as a fundamental duty on parents, that whoever, like if a child is under your custody, you need to send that kid to for this free and compulsory primary education. That means it was a general observation, not as such a legal observation that this law is having that fault or something. They just said that might be parents are only not interested to send their kids to school. But that simple observation also can have some impact. Okay, it's not necessary that it has to be relating to a law only. It can be as simple as like a random observation also.
And ma'am, like observation can be different, like can be differ by courts. Like if Punjab and Haryana High Court observes something else than the other court.
Yeah, it can differ, and that's why we are saying it's not binding as such, but it may be referred. Like if you are doing some research on a given topic, you may refer that in so and so case also this so and so judge made this observation. It's just an observation made. Okay, it, like we say, right, when you are watching news or a certain type of TV show, it has an impact on your mind. You also start thinking that way, behaving that way. So it's that way. Okay, when you are hearing the same observation again and again, you also start realizing that, oh, okay, might be problem is with parents or guardian only, that they are not sending the kids. Okay, it's fine, even though someone may have like a completely different opinion. That is also completely fine. They may say that might be schools are only not good, so kids are also not willing to go. That's completely fine, because it's anyways not binding, right? So there can be as many number of observations as there can be. It's completely fine there. Okay, but when we talk about ratio decidenty, like the supreme one will be binding, okay, which is having like more evidentiary value, like more importance. We will discuss which one binding, but still, okay, for precedent, this is important, ratio decidenty.
Okay.
Now you understood what is ratio decidenty, what is obiter dicta. It's like say by the way, like we say, right, okay, this is the situation, oh by the way, this also happened. So by the way is just by side of it, it's there, it's not that important, right? If you are talking something that okay fine, exams would be this time, that time, exams are going to start from November 1st week, this that, and you're saying, oh by the way, exams will be offline. That means it does not matter whether it's offline, online, you anyways need to study, but it's just a something that you said on the side of it. Similarly, obiter dicta is not that important also, but it's just on the side of it, judges made an observation. Ratio decident is the reason of decision. Definitely it's very important. Now, what is binding on whom? Supreme Court, it's apex court, highest court. Whatever Supreme Court has said, that will be binding on all courts in India. Okay, because it's Supreme Court. But what about high courts? Because Supreme Court, we just have one court. That's fine, we can follow it. But what about high courts? We have 25 different high courts. And like you said, Punjab and Haryana High Court may have a opinion or have a certain like a decision given, Karnataka High Court may give a completely different decision. Which one do we follow? Any idea what will happen in case there are 25 high courts giving 25 different types of judgment on one same issue? And Supreme Court is silent on that matter. Supreme Court has not yet said anything. So which high courts think who will follow?
I think Supreme Court is.
No, Supreme Court is silent on the matter. Supreme Court has not yet said anything because that sort of matter has not yet reached the Supreme Court. But all 25 high courts have said different things. Which one do you follow there?
I don't know. I don't like. I think there is some like, I don't remember the word, like called jury, which is made by the Supreme Court, like some bench of people who can decide this.
Is jury there in India?
I don't know. I don't think so. No.
You search if jury is there. Like it's not there in India, but which country jury's opinion matter, or in which country jury is there? You search on that. Okay. But in India, we don't have jury. Judges would decide it. And if Supreme Court is silent on a certain matter, if Supreme Court has said, fine, it will be binding. But if Supreme Court is silent and 25 high courts have given different opinions or different judgment, then what will happen, you know? One high court, right? One high court, under that all its subordinate courts should be there. Like if you take the example of Punjab and Haryana High Court, okay? Under that Punjab and Haryana High Court, all the lower courts that are there in Punjab, Haryana, Chandigarh, all those lower courts should come. That means whatever Punjab and Haryana High Court has said, all the other lower courts in Punjab, Haryana and Chandigarh will have to follow that thing only. Even though a certain judge or a magistrate might not completely agree to this viewpoint. Okay, that judge may feel that, no, this is like completely nonsense. This should not happen. It is not giving justice to any parties, but still they will have to follow it. That person from his heart, might be he agrees with another decision given by maybe High Court of maybe Madras High Court. But even then, even though personally he agrees to the viewpoint of Madras High Court, he need to follow this one given by Punjab and Haryana. Why? Because this lower court or subordinate court is coming under Punjab and Haryana High Court. Okay, so whatever Punjab and Haryana High Court has said, all its lower courts will follow that. Whatever Bombay High Court said, all its lower courts would follow that. Same goes for all the 25 high courts. Okay, is it clear?
Yeah, but ma'am, like for example, in the case of living relationship, like in like according to Punjab and Haryana High Court, it is still illegal. But according to like Supreme Court or like you can say other courts, it is legal. Like it comes under Article 21. So like in this case, I think, yeah, same situation. Yeah, okay.
Yeah, so and also sometimes what may happen, right? Maybe like I said, like 25 different high courts have given 25 different opinions, but might be there are 2 high courts, okay, where like 24 high courts give different opinions. There is just 1 high court remaining. Okay, might be High Court of Karnataka was silent until now. Karnataka High Court was silent on that matter, and now is the time when a case has come before them. Okay, so now they are free. They can either give like a completely different their own decision, or if they agree with any of those remaining 25 high courts decisions, they can follow that also. Okay, so it is having persuasive value. It's not as such binding on them, but if they liked judgment given by any of those 24 high courts, they can follow it also. All right, so whatever decision is given by Supreme Court, you can observe it like this, you know, like might be Supreme Court is your college teacher. Whatever your teacher is saying, you need to follow it because you know she is having authority, right? If your college teacher says that from module 3 only precedent is important, definitely you would give importance to her statement, right? Because she is having some idea, might be she will be the one who will set your question paper. So if she is saying that read precedent, one question will be there from precedent. That means you will, no matter what, follow her statement, right? You will somehow try to read it. But if same thing is told by one of your friends, that I feel precedent is important, from their question might come. In that case, your friend is at the equal level with you, right? Your friend is not superior than you. That means your friend and you are like two different high courts. There it depends. If you agree with your friend, you can read precedent. But if you feel that no, precedent is not that common topic, from precedent questions will not come, there you can simply ignore your friend also, right? So you and your friend are like two high courts. You can choose to follow the advice of your friend or not, but your teacher is like the Supreme Court. You need to follow that advice only. Okay, is it clear what is binding on whom?
Yes.
Okay, but then I said that Supreme Court's decision is binding on everyone. What about Supreme Court? Is it binding on Supreme Court? Supreme Court's decision?
Yeah, yes.
So is it like once Supreme Court said something, we cannot alter it?
No, like Supreme Court is binding by the Constitution.
Constitution to everyone is binding.
Yeah. So I think we can alter it, like any decision made by the Supreme Court.
But then what about precedent?
I'm confused.
So for Supreme Court's decisions, right, whether Supreme Court is bound by its own decision or not, there we need to consider. Are you aware there is a term called bench of Supreme Court?
Yes, ma'am.
You are aware. So what is a bench of Supreme Court?
I think like I heard in some movie, or like not that much of clear, but like it's similar. I don't have any idea. Like,
but you heard the word that there is something called
yeah,
bench of Supreme Court.
Yeah, yes, ma'am.
So bench of Supreme Court is what? Like what happens in a classroom? What happens? There are benches, right? There will be many different benches, and in one bench there will be few students sitting, right? And it happens, right, that we always sit with our friends only. That means there is this one bench where you will sit with might be two friends of yours. You are three people. Another bench where there is a bigger group, 5 people are sitting. In the same way, in Supreme Court also, when we say bench, that means how many people were there taking a decision on the matter. Okay, so bench of Supreme Court basically refers how many judges were present there deciding on a case. And when you are reading different cases, right, there also you will see 2 judges bench decided on this matter. Name of judges also will be written. 5 judges bench, 9 judges bench, then 11 judges bench, 13 judges bench, like that it will be mentioned. Okay, and by far largest number of judges were 13 judges bench, and it was Keswananda Bharati case. That was like the by far largest ever bench of Supreme Court. Okay, that many judges set together to decide on one matter. All right, so bench of Supreme Court basically means how many judges were there to decide on that issue. If there is just one person taking a decision, that means only one brain working there. If there are 5 judges, that means 5 brains working together. 13 judges, 13 brains working together, right? So that means decisions given by a higher number of judges, right? Like a higher bench will be binding on lower number of judges. Okay, and if you want to alter something which is decided by a 5 judges bench, it cannot be altered by a bench lesser than 5. It can be 7 judges, 9 judges, 11, 13, like that. Okay, so whatever decision is given by Supreme Court, it will be binding on a bench lower than that. if someone wants to alter it, it has to be by a higher number of judges that they can alter. Is it clear?
Yes, ma'am. Ma'am, then like what's the like purpose of Chief Justice? Like what he can do?
Purpose
Chief
of
Justice.
purpose of Chief Justice, again, he would usually take, for example, a important matter has come, court was deciding on it, but then later court felt that might be this is like a very important matter, we need to appoint many, like recently only last year, what Supreme Court realized, right, that because of this COVID situation, like just because COVID situation is taking place, everything is shut down, nationwide wide lockdown and everything, but that does not mean crimes are going to stop. Crimes will be there, people want to uh, approach the court to get justice. So Supreme Court realized that maybe we need to accept this technological developments, we need to start hearing people through video conferencing. So Supreme Court decided to take up that matter to pass certain guidelines that how we can initiate that process of online hearing, online filing of cases and stuff. Okay, so there what happened, right? Only Chief Justice this B.B.A, right? He was there and one justice was there. They both started with it. Later on, they felt that no, might be it is an important matter. So Chief Justice decided that let's add one more justice. Later on, they thought, no, let's add two more justices. So Chief Justice of India would decide how many judges are there, that many judges that person can assign. Chief Justice of India would also send recommendations regarding new appointments that are to be done. For that, he would be sending this from collegium, right? He would be sending recommendations and all. He is having a lot more functions. If the central government president is asking for some advice, he can give that. If he feels there is some important issue going on, he can take up that matter. He is having lot many different purposes, or for some cases, he would also say Chief Justice was also part of one certain bench and he also gave a decision. Okay, so he is also like part of that only. He is also like a justice, but then he is Chief Justice. Okay, he is having few more additional powers, functions, or authority as compared to other justices.
Like he cannot, like he alone cannot alter any judgment or like any law.
No, if it is given by a larger number of this, he cannot do. But if he single-handedly was deciding on a matter, he can say something on it. That is completely okay. Like if Supreme Court has not yet given any decision on a certain matter, in that case, he can do it. But not like something given by 13 judges bench, he cannot simply alter just because he is a Chief Justice. That would not happen.
Ma'am, just one more question, like who appoint this like bench of judges? There will be like 3 bench of judges or 4 bench of judges. Who will
It's
appoint?
not
Like,
like
who will make the
permanent.
decision?
Yeah, it's not like permanent that these many judges, these 3 people would sit always together. It's not like that. Case to case basis, they would decide. Okay, like the one I told last year, they took up the matter to decide on online hearing of cases and everything. There, Chief Justice can feel that, okay, might be this is an important matter. Let's add one more justice. So whoever is free, they can simply add that person also. It's not like hard and fast rule that these 3 people would be together, these 2 would be together. No like friendship sort of thing over there. They can decide on it. Whoever is free like that, they can assign this also. Okay, but then matters are being decided. Like we have one specific statute also which says these all matters, single judges bench also can decide. These matters, it has to go to this bench, it has to go to that bench, it has to go to bench containing more than 5 judges. Like that, we have matters segregated, but as such, which one would go to whom, who all will sit together, no such hard and fast restriction over there.
Okay.
Another thing that we have is kinds of precedent. So kinds of precedents. Now, depending on who is giving, how it is being given, what is the precedent saying, we can divide it. Okay, first one being original and declaratory precedent. And these are like very much understood from the word itself. Okay, when we say original precedent, that means it's like original, newly it has taken place. So original precedent is where judges create a new law and the same becomes binding. Like for a certain given matter, no law was already existing, and for the first time court has established it. In that case, we would say it's an original precedent. Like we were not having any law legislation as such talking specifically about witness protection. So Supreme Court introduced this concept of Witness Protection Scheme 2018, which is a detailed scheme talking about the rights and protections given to witnesses. So that becomes an original precedent. For the first time, Supreme Court said these are the things which should be given to witnesses to ensure their safety, because they are taking the risk and trying to help court in coming to a proper conclusion, right? So we need to provide these privileges to the witnesses. It becomes original precedent. For the first time, Supreme Court asserted that yes, these are the benefits which should be given to witnesses. Is it clear? Original precedent?
Yes, ma'am.
Next one is declaratory precedent. What is declaration?
Declaration is like some announcement.
Announcement sort of thing, right? That I declare this. Okay, like in certain affidavits and all also we say, right? I declare that I'm a citizen of India, I'm this, I'm that, all of that. So declaration is like I'm saying something. Okay, so declaratory precedent is where a known or established law is applied to a particular fact or case. Like already there is a law, already provision is there, it's written, it's already there, but then you are again asserting it, you are again declaring it. Okay, so take for example, there is Article 21 of Constitution. What is Article 21 of Constitution?
Right to life.
Right to life. So that means Article 21 is already there in Constitution. It's already written. You have right to life and personal liberty. Right? No person should be deprived of his right to life and personal liberty except according to procedure established by law. It's already there. It's already written. But what is life? What is liberty? That thing Supreme Court has asserted a lot many times. Supreme Court declared that even though under Constitution it simply says life and personal liberty, it also means privacy. It also means right to travel abroad. It also means right to clean air, right to education, right to livelihood. So many different things. That means provision was already there, law was already there. It's not like something they have invented or something, but they declared that these all things would also fall under it. This meaning is not just limited to this, it would extend to this much. That is nothing but declaratory. It was already there, it's declared again, it's properly established again by court. Is it clear? Okay. Original and declaratory?
Yes, ma'am.
So persuasive and authoritative and persuasive, this already we have mentioned, but I'll still tell you one more time. Authoritative precedent. What is having authority? It's like you cannot disrespect it, right? You need to follow it because it's having authority. Like I said, your college teacher is having authority. Whatever she says, you need to follow it. If she is saying precedent is important, you will have to read it, because there is almost 99% possibility that from there question is going to come. Why? Because of her authority. Similarly, authoritative precedent is something that must be followed by judges whether they approve it or not. Like I said, Punjab and Haryana High Court has given a decision. A judge from the lower court, from the subordinate court, he is completely against that decision. But that judge truly believes or accepts the decision given by maybe Karnataka High Court. But this judge cannot disrespect this authoritative precedent. He will have to follow whatever Punjab and Haryana High Court has said. So that decision becomes authoritative. Okay, so judge of High Court or any other court in India will have to follow decisions of Supreme Court. Similarly, whatever Supreme Court has said, we need to follow it. We don't have any other option. Okay, that is nothing but authoritative precedent. Is it clear?
Yes, ma'am.
In authoritative precedent, again, we have two classifications: absolute authoritative precedent and conditional authoritative precedent. What is absolute authoritative precedent? That means it's like absolute, you don't have any other option, right? Absolute authoritative precedents must be followed without any question. It does not matter how incorrect or like how much you are not satisfied or how much you disagree with it, does not matter. You need to follow it anyways. Like decisions given by Supreme Court must be obeyed by all the other courts in India, does not matter how much you are against that decision. That is nothing but absolute authoritative precedent where you don't have any other option but to observe it. Is that clear?
Yeah, yes, ma'am.
Next one is conditional authoritative precedent. That means, yes, it is authoritative, it is having authority, but then there is a condition. In some cases, it will have authority. In some situations, it might not have. Like the example which I told you, that decisions, authoritative precedents are binding. The court can disregard them under certain circumstances. Like Supreme Court is also bound by its own decision, but it can be altered, right? It is not binding on a bench which is like higher number of judges are there. Okay, if a decision was given by a bench of 3 judges, it will not be binding on a constitution bench where there are 5 or more than 5 judges. That is nothing but conditional authoritative precedent. That otherwise decisions of Supreme Courts are authoritative precedent. They are binding. But whether Supreme Court is bound or not, there it becomes conditional authoritative precedent. We need to look at number of judges sitting over there. After that only we can say whether it's binding or not. That is conditional authoritative precedent. Is it clear?
Yes, yes, ma'am.
Authoritative as in it's binding completely, but then it may be absolute authoritative precedent where we don't have any other option, but we need to agree. In conditional precedent, authoritative precedent, we can see number of judges. After that, we can clearly tell if it's binding or not binding. Last one is persuasive precedent, which means courts are not bound to follow, but it depends. Like I said, if your friend comes and tells you precedent is very important, it depends. If you feel that, okay, might be this friend is having some knowledge on previous year question papers, might be whatever he is saying is true. There it depends on you. If you feel like, you can believe. If you don't feel like, you can simply ignore his statement. That is nothing but persuasive precedent where court is free to take a call. If they agree, they can follow. If they don't agree, they can simply ignore it. Like decision of one high court will be persuasive precedent for another high court. But decision of one high court will be authoritative precedent for whom?
Sorry?
Decisions of a high court, on whom it will be authoritative precedent.
I think district court.
Yeah, right. All its subordinate courts, it will be authoritative precedent, but it will be persuasive precedent on other courts.
Right.
Yeah. So this is basically the classification that we saw. Kinds of precedent. There is original precedent, declaratory precedent, authoritative precedent, persuasive precedent. Authoritative is further classified into absolute authoritative precedent, conditional authoritative precedent. Is this clear?
Yes, yes, ma'am.
So what is original precedent?
Like which is bound, like which is given by the Supreme Court, or like which is bound by the Supreme Court.
Which is like, is it original precedent?
So, like, sorry, can you please repeat?
Okay, fine. Let's start from first. What is precedent?
I think previously made judgments.
So binding nature that we need to follow it. Okay.
Follow.
Fine. What is original precedent?
I think that like the precedents which are like originally made by the made by some court.
Okay. What is originally?
Sorry, ma'am.
What is originally then? Like, can there be like a duplicate precedent? What is originally?
Original is, ma'am, how can I like tell the meaning?
You can give an example. Fine.
Like provisions on GST is original.
Is it precedent but?
No.
Then? Yeah, so you're close, right? That original precedent means something which was not previously decided, for the first time court asserted it. Might be we were not having a legislation on that. For the first time court decided that we need this thing, right? Court issued some guidelines or something. Like I gave the example of witness protection scheme, where for the first time court said we need to have something like a witness protection scheme. So for the first time court has said something. Maybe previously we were not having any legislation on that matter also. What is declaratory precedent?
Like where there is a where there is only application of an already existing rule, like an ma'am, like can I tell you tomorrow, like I have like too many questions. First, I need to read them. Like I need
fine. Yes, I agree. Okay, but I think you understood it. That declaratory is something which is already there. They are just declaring it one more time. Authoritative as in it is having complete authority, fully binding. Persuasive as in it depends on the judges whether they want to follow or not.
Yes.
Yeah. And for authoritative, we have two more classifications: absolute authoritative precedent, which is completely binding only, no other option, like Supreme Court's decision on all the other courts. It is absolute authoritative precedent. Conditional authoritative precedent as in there is a condition. Supreme Court is bound by its own decision or not, there is a condition. How many judges gave that decision, and at present, how many judges are there to decide on the matter? Based on that, we can say it.
Yeah.
Fine, then you can read this part. Okay, and yeah, so tomorrow we will discuss one more topic from the syllabus. Now there is a concept stare decisis. What is it? So stare decisis is Latin word for to stand by things decided. So stare decisis is also same like precedent only. So the doctrine of precedent in Britain is called the stare decisis. All right. What is it? Again, it means same, to stand by things already decided. What is things? Like if you have already given a judgment, all right, then I should stick by that rather than again wasting my time, effort, energy, because you have already done research on that. You have already applied your mind, logic and everything. Whatever decision you have given, I should try to follow that rather than I applying my mind there. All right. So it's also same.
This all will come. This all will come under interpretation of law, ma'am.
Yeah, under like for your fourth unit, right? These are the important questions that were given from your college.
Okay.
Okay. So these are under unit 4 only you have, so you can accordingly read.
Okay.
So stare decisis is also same like precedent only. Whatever is already decided, you stick by that. Okay. So it means when a rule has been settled law, it is to be followed, although some possible inconvenience may grow from a strict observance of it, or although a satisfactory reason is wanting, or although the principle and the policy of the rule may be questioned. So there sometimes it may be like you may not agree to that given decision completely, but still you need to obey. Like how we saw, right? Supreme Court decisions are binding on High Court whether you follow or not.
Yes, ma'am.
Right? If you are a judge of Karnataka High Court, something has been given by Supreme Court of India. Whether you agree to that decision or not, you will have to follow that.
Okay, ma'am.
Object of stare decisis. Why do we have this concept? The basic reason behind the doctrine of stare decisis is maintenance of consistency and certainty. Certainty, predictability, and stability in law is considered as the main objective of legal system. What is certainty? If we follow the same thing again and again, we know, right, that this is only what is going to happen. Like for all the different law colleges across India, you have semester exam. If you are applying for 5 years law course, you need to appear for 10 different semesters, right? That means what, there is a certainty. You know for sure that there will be 10 semesters that you need to appear for, right? And there is also a predictability that after every 6 months you will be having exams, and accordingly you will get marks and be promoted to next semester. There is a predictability. You know that, okay, fine, maybe my exams are coming because it's almost like 5 months now, right? That is predictability. And stability, that means same, right? You know, okay, fine, for the next 5 years, I need to be appearing for 10 semesters. Every 6 months, I will have semester exams. That means what? There is a stability, right? Same, you know the thing basically. So stare decisis also helps in the same way that we know, okay, fine, for this case, this kind of a judgment may come, right? Everyone knows that, like there is uniformity with regard to that.
Yes, ma'am.
Doctrine of stare decisis in India. The doctrine of stare decisis as is understood today appears to not have existed in India during ancient or medieval times, right? So in ancient times, this concept was not there, but it is only after British came to India and they started influencing India's legal system and everything, they brought this concept of binding precedent, right? That whatever is already decided, that is binding. Precedent, concept of precedent came into force. So British rule led to hierarchy of courts as well, that it's not like all the courts are at the same level, but there will be different hierarchy of courts as well, Supreme Court at the top. So accordingly, this principle is applied in India, that you can write and then you can give one conclusion, that while statutes and enactments or legislations laid down the general rule to be applied, with regard to this interpretation of final authority is with regard to judiciary only, that they will interpret the provisions accordingly, it will be applied. Why it helps is that once something has been decided, by putting all your effort, logic, reasoning and everything, we should stick by that rather than again and again changing our views, right? Basically, so you can accordingly write a simple conclusion of 2-3 lines. Is this part clear? What is stare decisis?
Yes, ma'am.
Clear, right? Any doubts on this part you can ask,
Yes,
like whatever we discussed till here.
First, I'll read and I'll ask you tomorrow, ma'am.
Okay. So are you finding it like something, like are you able to relate to it, or you feel like what is stare decisis? Why is it even there, kind of a thing? You can tell frankly, right? What is it? Are you finding it like that?
Yes, ma'am.
You're finding it difficult, is it?
Somewhat, what functions of law is it fine for me, ma'am, but it's difficult somewhat else.
Okay,
Today's
precedent.
Yeah, I can understand, ma'am.
You can understand. So Precedent you can understand. What is precedent? It is decision of a court, right?
Yes, ma'am.
Take for example,
Yes,
there is a dispute between you and me. Both of us went to court and court gave an order. Okay, that order is a precedent, right? That order, judgment of the court, we need to follow it. In all the coming days, we need to follow it. That becomes precedent. Precedent you understood, right?
Yes, ma'am.
So precedent and stare decisis is same only, right? Just we have difference in terms of name. In Britain, it is called the stare decisis. In India, it is called this precedent. But it means same thing only. That whatever is already decided, you follow that. Okay, just difference in terms of name.
Okay, ma'am.
Okay, so there also judicial decisions are binding in India. Same in Britain, also judicial decisions are binding. So decisions of higher courts are binding on lower courts, but lower courts decisions are not binding on higher courts. Right? It is basically same thing only. What is the object of this thing? That we have certainty. Today something is being decided. Tomorrow it should not be completely different. And then next day it's completely different. That should not happen. And that is the reason why we have this concept of precedent or stare decisis. It's the same concept basically. So what about this thing, interpretation of law? Are you finding that also confusing?
No, ma'am, I can understand it.
You can understand. So what is it that you are finding difficult? Stare decisis only or anything else also is there?
No, this one only, ma'am.
This
Stare
one only.
decisis.
Stare decisis, same. You understood precedent. What is precedent? Judgment of a court which is binding on lower courts. Same thing, same concept, just the name is different. All right, just the name is different. It is called the stare decisis. Okay. So in case of stare decisis, what happens again? To stand by things decided. Already a decision came. So you need to stand by that particular decision. This doctrine of precedent in Britain is called as stare decisis. That means in India we call as precedent. In Britain, this same concept is called as stare decisis. What happens here? Why do we need it? In order to maintain certainty, predictability, and stability. So that if today someone has committed the offense of murder and he is being punished with 10 years of imprisonment, tomorrow I cannot say that this person should get 1 year of imprisonment. Why? Because there should be like it should be somehow similar, right? It should not be completely different, so that there is certainty. We know that, okay, fine, might be this is going to happen or somewhat close to this is going to happen. So if we are following these already decided things, then it ensures that there is predictability, certainty, and stability. We can guess what is going to happen, right? Like take for example, when you see previous year question papers, you get an idea, right, that there is going to be 10-mark question, 6-mark questions. You need to answer these many questions and all of that, right? But if every single semester they are changing question paper pattern, what will happen? You will find it difficult, right? When you are going to write exam, you will see, there are some 2-mark questions also, there is one 25-mark question also. In that case, it will be very difficult for you, right? So same happens here also, that they should follow same kind of pattern. Like for your university, they are having same pattern for years together. Why? So that students can have some kind of a certainty, predictability. They can feel ki, okay, fine, 10 mark is the highest mark, so I need to prepare everything for 10 marks. That means you can predict what kind of questions will be there in your question paper, right? And accordingly prepare. Same happens here also, that you have an idea what may be the kind of decision that is being given, and accordingly you can, you can predict it basically. So doctrine of stare decisis in India, previously, right, British came to India, right? But previously, before British came, we were not having this concept of stare decisis, right? Whatever is decided today, it's decided tomorrow. Again, they will decide panchayat and everything, right? After British came, what happened is they started with this concept of following previous decisions, right? So after British came in India, we had this concept of precedent. We call it as precedent, they call it as stare decisis. But British only introduced this concept, and they also clarified regarding hierarchy of courts, right? That all the courts are not equal, but there is Supreme Court, which is highest court. Then we have high courts. Then under that we have some civil courts, municipal court, judicial magistrate court, right? So this hierarchy of courts is also given by Britishers only, and they only made this particular doctrine applicable in India, and we call it by the name precedent. Okay. So from this part, right, I will just try to remove some of the unwanted parts, and will try to simplify this one so that you can directly read from here and prepare for your exams. All right, for 10 mark,
Okay, ma'am.
you should have enough of information. So I will give you this document with these 4 questions. Okay, so we studied about precedent, right? Precedent or judicial decision, we studied that part, right? That judge would give a decision while deciding a case, and that decision becomes binding on lower courts. That is the rule of precedent. Now there was a question asked, explain the circumstances affecting the weight of decision of the court. That means a court gave a decision. What are the factors that will affect weight of the decision? That means how much authority that particular decision will have, right? What are the factors which will affect weight of a decision? Now, affecting weight means it may be in a positive way or in a negative way, right? It may increase weight of the decision, or it may decrease weight of the decision, right? So you need to know points for both the two things. Okay, if they are simply mentioning what are the circumstances affecting weight of a decision, you can write both, that these are the points which will strengthen the validity or authority of a decision. These are the points which will weaken authority or validity of a decision, right? And if they are specifically mentioning what are the situations that will lower validity of a decision, then you can mention that only. Okay, I'm giving you overall, whatever they are asking, accordingly you can write. All right, if it's a general question, you write both. If they have specifically mentioned regarding increasing weight or decreasing, you can accordingly frame your answer. So for this, you can give one intro saying what is judicial precedent, right? So judicial precedent refers to previously decided judgments. Why is it important? Because it saves time. Every single time you are not bothered with the same kind of matter. You can simply refer to the previous decisions, like that you can mention. So now also precedents are given much value and all that stuff you can write in your intro. Then you can mention circumstances affecting weight of a decision. It is important to understand the extent to which courts are guided by precedent. That means, yes, for sure, courts do follow decisions given by a higher court. But to what extent do they follow? Is it like they just obey whatever is given by higher courts, or what is it, right? So it's very important that we understand the extent to which decisions of courts are courts are guided by precedent. There are some circumstances which would affect decisions of court, right? Abrogated decisions. A decision ceases to be binding if a statutory rule inconsistent with it is subsequently enacted, or if it is reversed or overruled by a higher court. That means, for example, High Court of Karnataka, you are a judge of High Court of Karnataka. You gave a decision, okay? You gave a decision that, some decision you gave, okay, that child labor is very bad, it should be prohibited or something like that. Now, Supreme Court, what happened is Supreme Court gave another decision which was like reverse of yours. Like Supreme Court is higher means that decision will be binding. That means the value of your decision will come down, right? Why? Because we cannot follow decision of Karnataka High Court, but rather we will have to follow whatever decision is given by Supreme Court. Is it clear?
Yes, ma'am.
Okay, so it can be done either by a higher court that they have changed the decision, or maybe legislature has passed a statute. Okay, a statute has been introduced which is saying in a different way. Okay, it is not based on whatever the judge had decided. So in that case, you either will have to follow whatever is given by the legislation or whatever higher court say. In that case, value of the decision will come down. Same decision on appeal is reversed by appellate court. What is appeal? You are not happy with the lower court decision, you go to a higher court. You again file the case, right? And based on merits of the case, it will again be decided. That means you are not happy with this lower court decision, you are going to a higher court. If in high court some decision came, you were not happy with that decision, you went to Supreme Court, Supreme Court gave another decision, it altered the judgment of high court. At that time, this high court ka judgment will not have any authority, right? Why? Because this is already altered at the stage of appeal by Supreme Court. Is it clear?
Yes, ma'am.
Sure, right?
Yes.
Okay. So High Court of Karnataka gave a decision, its value may be reduced. How? That Supreme Court gave another decision in some other court, which was like reversed. Or maybe a legislation or a statute came, which was something different only, right? Its value will come down. Similarly, if High Court of Karnataka gave a decision in some case, okay, Pranati versus Minakshi, High Court of Karnataka gave a decision. We were not happy with the decision. We went to Supreme Court of India. Supreme Court reversed this decision. That point of time also, this decision will have no value, right? Why? Because it was...
Case laws always, case laws always will come. Case laws will always will come versus, no, ma'am. Means like Pranati versus Meenakshi, like that it will come, no, ma'am.
Yeah, for civil matters, it would come like that. Like if you are filing a case against me, it will be like you versus me.
For criminal, ma'am, it will come like that actually.
For criminal, it would be like, if you are filing the case, right, it would be like your name versus state of Karnataka or Union of India if it is central. Okay, because criminal matters, right, like crimes are considered to be committed against the whole society. You are, even though you are committing a crime against me, like some murder, kidnapping, something, you are committing the crime against me, but it is considered as if you are committing crime against the entire society. So it will be always versus state versus Union of India, like that you would see.
Okay.
Next is affirmation or reversal on a different ground. A decision is affirmed or reversed on appeal in a different point. Again, it is basically altered at the time of appeal. That will also bring down its value. Ignorance of statute. That means you gave a decision being judge of Karnataka High Court, but you were not knowing about a certain statute that is existing. All right, might be there is a very uncommon statute that is there, and lawyers are also not aware, you were also not aware, you gave a decision. Okay, then after that point, what happens is it will not have that much of value. Why? Because there was ignorance of statute. Inconsistency with earlier decision of High Court. A precedent is not binding if the court that decided it overruled an inconsistent decision of a High Court. High Court cannot ignore decisions of Supreme Court of India. Okay, that means High Court is like there are two different decisions given by the same High Court. At that point of time also, one of the decisions value would come down. Inconsistency with this earlier decision of same rank. A court is not bound by its own previous decision that are in conflict with one another. The Court of Appeal and other courts are free to choose between conflicting decisions, even though this might amount to preferring an earlier decision as to later decision. That means in Karnataka High Court, 5 judges gave a decision, another 5 judges gave a different decision. All right, in that case, you can decide which one you want to follow. Why? Because these are like completely opposite to one another. So that time also its value may come down. Precedent not fully argued. When a point is not involved in a decision is not taken notice and is not argued by a counsel, the court may decide in favor of one party. Hence, such where if all the points had been put forth, the decision is one favor of one party. Hence, such rules precedent not fully argued. So basically, if one party had not represented his or her side properly, in that case also, we can say that there was no, like enough opportunity was not given to both the parties to put forward their point of view. So that time also we may say that it is bringing down value of the decision. Okay, these are basically points which will bring down value of a precedent. All right, whatever is binding on us, it is bringing down value of it. Then there are certain situations which will increase authority of a precedent, right? That means precedent, it was already there, but it is increasing authority of that precedent. How it can increase? The number of judges constituting the bench and their eminence is very important factor in increasing the authority. That means how many judges were there? Was it group of 5 judges? What is group of 7 judges? 9, 11, how many judges were there sitting there and giving the decision? All right, if it was like 13 judges bench, obviously it will have more value, right? And also it will depend on who all the judges were. Were they like very, like well-known judges who have given landmark judgments, or they are like very new judges, right? So their authority would also determine how much of authority the precedent will have. So basically number of judges and how famous are they, how well versed they are with law, right? That thing also will decide it. Next is a unanimous decision carries more weight. That means, take for example, it was like a 7 judges bench. All right, 7 judges had to decide on the matter, and all the 7 judges agreed to the same point. Okay, there was not like 2 judges said something else, remaining judges said something else. It was not like that. All the 7 judges agreed to the same thing. In such cases also, that particular decision will have more value. Why? Because all the judges agreed to the same point, right? So in such cases also it will have more value. Affirmation, approval or following by other court, especially by higher tribunal, adds to strength of the precedent. Take for example, Supreme Court gave a decision, everyone started following it. Or High Court of Karnataka gave a decision, all the lower courts coming under it started following it. At that time also its authority would increase. All right, that people would start following it or obeying it, right? Its authority would increase in that case also. If an act is passed embodying the rule in precedent, the gains and added, it gains an added authority. That means whatever you said in your judgment, right? If there is a statute that is introduced, agreeing to whatever points you mentioned at that point of time also, what happens is, at that point of time also, its authority would increase, right? So take for example, if you said in a certain case, all right, you said that parents are having a duty to send their kids to school. Right? So parents are having a duty to send their kids to school. You said that in your judgment. Otherwise, what happens is child labor and other problems would increase. So you just gave that in your decision, and after that, there was a statute that was introduced that it's a compulsory duty on parents that they should send their kids to school. Otherwise, they will be liable for some sort of a punishment. That time, what happens is the value of your decision would increase. Why? Because even a law is introduced that is also saying the same thing only, right? So these are some points which will increase authority of a precedent, and those were some points which will decrease authority of a precedent that we have. All right, is it clear this part?
Yes, ma'am.
So we have we studied something called as interpretation, right? So do you remember what is interpretation?
It's like elaborating the laws, the golden rules, using this thing, understanding of laws, basically.
Understanding of laws, right? So we try to derive meaning, or we try to understand what is meaning of certain words which are being used in the legal text or in the statute. That's what we see interpretation. There is another word which is used, that is construction. Okay, both are a bit similar. Interpretation, as in we try to understand meaning of the provision or meaning of the words given. Okay, there is another word called as construction. Okay, now what is construction? It means drawing conclusion from the written text. Fine, there is a provision applicable. You understood meaning of the provision, but what would be its implications, right? What will be the outcome of that particular provision? That's nothing but construction. Okay, so interpretation refers to the linguistic meaning of the legal text. What this certain provision means, that you understand by way of interpretation. But the purpose of construction is to decide the legal effect of the words. Because this certain thing is written, because we have derived the meaning, now what would be its effect or its implication, that we try to find out by way of construction. So in the case where the simple meaning of the text is to be adopted, then concept of interpretation can be applied. But in case where literal meaning of the legal text results in ambiguity, maybe it's not, it's like confusing or it's difficult, right? In such cases, construction is to be adopted. Like I mentioned, that if you are translating a statement from Hindi to English, if you translate it word by word, it might become meaningless. We need to see the entire sentence, and then we need to translate it, because the construction of sentence is a bit different in Hindi and English. Same ways, in case the by deriving meaning of the written words, if it's not making sense, if it's ambiguous, we may take help of construction over there. Okay, so when we talk about construction or even for interpretation, there are certain aids which are being used. Okay, so there are certain aids. So what is aid?
Aid is like helping, ma'am. Something
Helping. Correct.
Support.
Right, we say, right, legal aid. You
Yeah, ma'am.
have legal aid, or might be you have already got legal aid program. Some places they would take you. That's nothing but helping, right? Like we say first aid provider, or some aid is commonly used, right? So here we are saying internal aid to construction, as in internally there are certain things which are going to help us in construct or in interpreting different provisions of law. Okay, so what is internal aid? Internal aid to construction are used by, again, courts to derive conclusion from the legal provisions of different statutes or different rule books. Construction refers to drawing conclusion from the written text which is given in a statute or which is given in a legislation. We try to derive conclusion from it. And the purpose of construction is to find out the legal effect of the written words or the written rules. Now, when we talk about aid to construction, aid is nothing but a device that helps or assists in performing some work. While performing function of construction, the court can take help from certain things which are present within the statute itself. From there, we can take help and we can understand meaning of a certain thing, or we can understand impact of a certain provision. That's nothing but internal aid to construction. Some examples would be title, heading, preamble, etc. However, if the courts take help from outside the statute, it is called as external aid to construction, like government circulars, publications, etc. Apart from the legislation, there may be some other things from where we derive some information to understand meaning. Okay, that is called as external aid because it's not there present within the statute. Sometimes you would see there will be a legislation and there will be different rules based on that. So you can take help of those rules to understand meaning of a certain provision. That's nothing but external. Okay. For example, central motor vehicles rules, like that rules will be there. Okay, so just to give an example, Right to Information Act. You must have heard of it, right? What is this legislation?
Like right to information, like for example, auditor has to give information about our auditing and all those stuff. We cannot hide those information from us to like to audit or something like that. We have right for that auditing information. What it does.
We have right to seek various public information. So when we
Yes,
talk
ma'am.
about this Right to Information Act, sometimes it might happen that you are seeking a certain information which is contained in 1,000 pages book. Okay. Now maybe I am a certain department, you are asking me for that information, and that information is available in like hard copy. Okay, it's not available in soft copy. Now, if I need to provide you that information, it would be very expensive, right? 1,000 pages I need to Xerox, print out, or whatever. In such cases, what I will do is, or also to ensure that you are not just, like asking for any random information, because when you need to pay, you will ask for whatever is needed, right? You would not randomly start filing RTI applications. That's why this information is not provided entirely for free. Okay, whatever is the cost of providing the information, that cost the person has to pay. Now take for example, you are applying for certain information. Okay, how much you need to pay for that 1,000 pages, or to apply for it, what is all these rules and regulations, right? It's not given under this act, but it's given in something else called as Right to Information, Regulation of Fees and Cost Rules. As in, most of the acts will have a rules. Okay, so rule book would tell you details about certain rules and regulations that apply. So if you are taking help of these rules to understand a certain provision, there we will say it is external aid to construction. Okay, it's not within the legislation, it is external. But when we say internal aid to construction, it would be what we get inside the legislation itself. Okay, clear, right? Now, when we talk about internal aid to construction, one is very important, that is preamble. So preamble is nothing but like the starting point of a certain legislation, which explains what is the meaning or purpose of this certain legislation. Okay, so preamble is very important, which tells us what is the purpose of this legislation and what this legislation is all about. It's nothing but one of the very important internal aids to construction. Okay, then we have long title and short title. When you open a certain legislation, you will see details. Okay, so short title, extent and commencement of the act. So you would get the entire details. What is name of this legislation is Right to Information Act. In short, you might say as RTI Act. It extends to the whole of India. All this extent, commencement, title, all of this also is nothing but something which helps us interpret the provisions or construct the provisions. Okay, like if you want to know if a case has been application has been filed in Jammu and Kashmir, whether person can seek that information or not, there you can see the extent of this legislation, and you can decide whether RTI Act would be applicable in Jammu and Kashmir or not. Like that, these provisions also help us a lot in deriving meaning out of a certain thing. Okay,
Ma'am, it's there in parts of statutes also, no, ma'am? Long
yeah,
title,
parts of
short title.
statutes also, correct. Parts of statute
Okay.
also it is there, because within statute, what are the things which help us in construction? Same ways we have
Okay.
preamble, starting point of the legislation, or
Constitution.
gives details.
Constitution also there is preamble.
Yeah, constitution also there is preamble. Most of the legislations will have a preamble. Okay, sometimes you would see it like an objective, it is written like an act to provide for setting up of practical regime, like why is this legislation, like that sort of objective or preamble you would get in most of the legislations. Okay, then we have heading and title of the chapter. So it might be arranged in different chapters, in different parts, in different headings, we would get it. Then we will also get definitions under a certain legislation. Like when they say right to information, from whom can we seek information? Is it that you can file an application to me asking, okay, what is the color of your house? That is not information what we can seek. Okay, so what information we can seek, that's also being defined just to make it clear. Okay, so all these information we can seek, from whom we can seek, that is also mentioned. Who should be providing that information, that is also being mentioned. Okay, so there was like a lot of people think that okay, there is something called as RTI Act and they can seek for any information. Okay, so there is one organization, okay, where I worked. They were helping in filing RTI applications. Okay, RTI is first appeal, second appeal, and everything. There, one person had requested to file an application that my wife is, I think my wife is having extramarital affair. I want to know with whom she is having an extramarital affair. So that was the kind of information that people want to seek. So that's not something which can be provided, right? So it's very important that we define these words so that people are clear on what you can ask, what you cannot ask under this act.
That's common. That all comes under definition, like.
Yeah, that's why definition is important, so that people do not think that they can just randomly ask anything, right? So this is important.
Okay.
Then we have illustrations also, which help us understand the complicated provisions, like in Indian Penal Code and all those legislations. Illustrations help a lot. Then we have proviso also, that this is what generally happens and this is what in a specific situation would happen, like provided exceptional situations are mentioned there. Then we have explanations also. Sometimes a provision may be given, after that they would give explanation 1, explanation 2, just to make it very clear. It's commonly seen in Indian Penal Code because provisions are complicated there.
Ma'am, proviso means what, ma'am?
Proviso is like exception. Okay, this is what it is, but provided or exception. Okay, like as a general rule, contract without consideration is not valid, but it might be valid in some cases. What are those some cases? That's nothing but proviso. Okay, proviso is like exceptional situation. In normal situation, something would happen, but there are few exceptions to that general situation. That's nothing but proviso.
Okay.
What are schedules? Do you remember schedules?
Schedules are like, for example, Bear Act, ma'am. Can be tell as schedule, which tells us like, for example, Motor Vehicle Act, it tells us how to ride on, like following. I don't know how.
It's
That was done in
information that you
additional information.
Yeah, like
Yes,
under Motor Vehicles Act, you would get the details in schedule that what sign or signal means what.
Yeah.
Right? That is nothing but.
Like in general, we can detailing definition of certain information.
Yes, detailing. Detailing, not like definition, detailing, you can say, detailing of certain information. Then we have punctuation also, which also helps us because that's how we properly understand a certain word, right? Without full stop, without comma, it would become like confusing otherwise. So punctuation also help us understand. Yeah. So these are nothing but internal aids of construction, which are similar to the parts of statutes, which we have. There is one more question, which is, what are different types of legislations in India? We will see this. Okay, so the term legislation, it's derived from two words, legis and letum. Legis means law, letum means making. So legislation is nothing but the process of law making of laws. When we talk about different sources of law, from where law has originated, from where we derive the law, legislation is also considered as one of the very important sources of law. Okay, so it is one of the most important instruments of governance, and it also helps in maintaining peace and order in the society, because it's mostly legislation from where we are deriving the laws at present day situation. We have thousands of legislations which are applicable in India, and by looking at the legislation, we know what provisions apply and what provisions are not applicable. So it determines, among other things, the rights and responsibilities of individuals and authorities to whom the legislation applies. What are our rights? What are our responsibilities? And what are the rights and obligations of other authorities also? Everything is decided by way of these legislations only. Right? When we talk about our rights and obligations, IPC gives us some obligations, that I should not cause harm to another person. Under contract, contractual obligations are fixed. Under labor laws, obligations are fixed for employer. Right? Like that, we have different rights and obligations clearly specified by way of legislations. There are numerous reasons. There are numerous reasons behind the introduction of different legislations. For instance, a legislation may be enacted to direct, to approve, to endorse, to give, authorize, allow, proclaim, confine, or to annul, etc. So there are different reasons why a legislation may be introduced. Sometimes legislation imposes powers on someone. Sometimes legislation imposes some obligations on another person. Sometimes it's there to give rights to another person. Like that, there are different purposes which a legislation fixes. Okay, sometimes just to give clarity on a certain matter might be a legislation may be there. Like we have General Clauses Act defining certain words, right? There are legislations to specify the procedure that needs to be followed in the court, like CPC, CRPC, right? So like that, we have different legislations performing different types of functions or different reasons why those legislations were being introduced. Okay, talking about the different types of legislations, we can classify it into supreme legislation and subordinate legislation. And within subordinate legislation, we have 5 more classifications. Okay, so what is supreme legislation? Supreme legislation is the legislation which is made by sovereign authority of the state. It cannot be repealed, controlled, or amended by other authority except for the one which it precedes. As in, supreme legislation means a legislation which is passed by like the legislature, like the highest lawmaking authority, it would be passed, and it can be changed only by those authorities. It cannot be changed, repealed by an authority which is subordinate to it. It is enacted by highest lawmaking body. In case of India, this is Parliament. So all the acts of Parliament are thus supreme legislation, because when Parliament passes a legislation, we cannot change that legislation by, like, state legislature cannot make changes in the legislation, right? It's only Parliament. When we talk about Constitution of India, Constitution is not made by Parliament, but there was a different committee which was formed, right? Like the Constituent Assembly. Different assembly was formed and which made the Constitution. But then power is given to Parliament, because Constituent Assembly was there only until Constitution was made applicable. But Parliament is like a permanent body, right? So that power was entrusted to Parliament, that even though it's like passed by a constituent assembly or different body altogether, Parliament will have power to make changes there. Okay, so that's nothing but a supreme legislation. Constitution is an example of supreme legislation. The authority of constitution cannot be challenged by any other legislative power. However, authority of X may not be supreme. This is because in India, court of law have power to declare legislation ultra vires or unconstitutional. When we say this legislation is supreme legislation, It means that any subordinate legislature cannot make changes. If Parliament today passes a legislation, a state legislature cannot say that this law is repealed, this law is void or something. Okay, so when the legislature passes a law, supreme legislature passes a law, any subordinate legislature cannot make changes there. But then judiciary is a different organ. Judiciary is given a lot of powers. So judiciary can make changes and judiciary can say that no, this legislation goes against so and so provision of constitution, so it is unconstitutional. Okay, it is called as doctrine of judicial review. As in judiciary can see whether this legislation is proper and valid or not. If it goes against provisions of constitution, then judiciary can say that this is void. Okay, so this is what supreme legislation is, that its subordinate legislature cannot declare it as void. But we have a different provision for judiciary. Courts can declare it as void if it goes against the constitution, because constitution is like the supreme law of land in India. Okay, is it clear?
Yes, ma'am. Ma'am, like amendments on constitution can be done only by whom, ma'am? Parliament.
Yeah.
No court can do that. Supreme Court also.
Court would not do amendment as such. Court might say that.
No, I'm asking like court might say no, ma'am, but there might be an amendment in this. Opinions, basically.
Yeah, that would be just an opinion. It depends on Parliament whether they follow or not. Court keeps on saying a lot of things, that on this matter we need a legislation, this change we need in a legislation, but that's just an opinion. It depends on Parliament whether they would consider it or not.
Oh, okay.
Okay, so amendment as such, only Parliament is having the power. Then we have something called as subordinate legislation. So subordinate legislation is that which proceeds from any other authority other than the sovereign power. It is made by an entity under a power delegated to it by Parliament, and it is also known as delegated legislation. It is necessary for legislative powers to be delegated because it saves Parliament from undue pressure. It saves time and also follows a swift action to be undertaken in cases of emergency. Examples of subordinate legislations include rules, regulations, policies, notices, proclamations, etc. There are 5 kinds of subordinate legislation that can be understood as follows: bylaws made by Delhi Municipal Corporation and Municipal Corporation of Mumbai, Delhi High Court rules governing High Court, etc. Now what happens? Parliament is like a specialized body which is having the lawmaking power. Okay, now if Parliament is having power and Parliament is taking care of all the laws that we need in the country, Parliament will be overburdened, right? And also it would take a lot of time for simple laws also to be passed. So it's not needed that for every single law we would be bothering the Parliament. And that's where the concept of delegated legislation comes. Okay, delegated legislation. Delegate means to give it to someone else. Okay, so if you are maybe like you are manager of a certain company, okay, company owner has given you some work. You cannot take care of all the work. So what you will do is you will give those work to your team members, as in you are delegating your work. You are giving it to your subordinate employees. That's nothing but delegate. Okay, so when we say delegate legislation, that means Parliament is not taking care of everything, but Parliament gives some powers to those other bodies that you take care of these matters, you take care of these matters. Okay, that's nothing but delegated legislation. From Parliament, some powers are given to its subordinate authorities. For example, Delhi Municipal Corporation. Now, municipalities, they play a vital role, right? They also have a lot of rules, regulations that needs to be followed. In case Delhi Municipal Corporation wants to pass some rules, laws, etc., they need not get it passed from the Parliament. Okay, they can make this themselves. Might be they want to ban plastic in Delhi, and if anybody is using it, they would charge this much of fine. maybe throwing garbage on the road, this much of fine. Okay, all these are nothing but they are having the power to make the law. Okay, as such, it's not needed that it should come from the parliament, right? If we give that power to Delhi Municipal Corporation, it would save time of everyone. Also, laws can be introduced very quickly, right? So that's nothing but subordinate legislation wherein power is delegated to these bodies. How High Court will operate, like High Court of Delhi, how things would happen there. Okay, some procedural matters. There we need not bother the parliament again. High Court can pass some rules relating to that so that the process becomes easier and quicker. Okay, is it clear?
Yes, ma'am.
So there are different kinds of subordinate legislation like colonial legislation, executive legislation, judicial legislation, legislation under local self-government, autonomous legislation. So colonial legislation, British Empire had many colonies around the world. British Crown and its parliament entrusted power of self-governance to these colonies by which colonies enacted laws. Colonial legislation was dependent for its continued existence and validity on British authorities. The British Parliament had the power to alter, repeal, or supersede any law made by these colonies. For example, law passed by Indian legislature before independence. So all these different colonies that were there, in order for those colonies to survive or to for their functions to be run properly and smoothly, British government gave powers that you can make laws which would be applicable in your specific colonies. But then British government was having the power, British Parliament was having the power that they could make changes in those laws also. For the purpose of operation, you make laws. But if anything is conflicting, British Parliament reserved the right to make changes over there. Okay, so colonial legislation was something which used to prevail earlier times. Executive legislation we have. So legislature often.
Now it's like we don't have colonial legislation.
Yeah. Now we don't have it. Okay. So what is legislature and executive? What is the difference between them?
Executive is like binding force, ma'am. Like they see whether the things are going well for like executing the law. And one more thing, ma'am.
Executive.
Yeah, that's the thing I told.
Yeah. So legislature means the lawmaking authority like parliament, state legislatures, etc. Okay, executive is like different departments that we have in India. So executive is what? Executive is like the different departments that we have. Okay, different departments, different ministries that we have. So what is executive legislation? Legislature often entrusts its lawmaking power to executive organs of the state. Ideally, legislature should be making the laws, but sometimes they give that power or they pass on that power to executive or the different departments also. For example, when the parliament or state legislature is not in session for meeting an emergency, the executive may proclaim an ordinance in the nature of law to tackle the problem. Okay, like the president is having the power to pass like an ordinance. Okay, it would be applicable for a certain duration only because might be some situation wherein we need a law urgently. Okay, so their ordinance may be applicable, and later on when the parliament is having time, parliament would pass a law. Okay, so that's nothing but executive legislation. Executive is given the power that because you need to look into day-to-day affairs of the state, you can pass a law over there. Okay, so according to Article 13, Clause 3, Clause A of Constitution, law includes any ordinance. Order law does not only mean a legislation, but it includes a lot of other things also, like ordinance, order, bylaws, rules, regulations, notifications, customs, usages. A lot of things are included over there.
Okay.
Okay, so this is nothing but that executive is given the power that in case there is any emergency situation, in case you need a law urgently because we are not in session, you can pass a law which should be applicable for the while. That's nothing but ordinance. Okay, then we have judicial legislation. Powers delegated to judicial system to make and implement their own laws to maintain transparency in judicial system of the country. This will also ensure that there is no involvement of any other organ of the government in governance of judicial system. Like Supreme Court and High Courts are entrusted with rule-making powers for judicial administration. Judiciary is delegated with rule-making powers under Article 145 and 227 of Constitution. For example, like I mentioned, Delhi High Court rules how Delhi High Court would function. Right? We have something called as Supreme Court office procedures that is also passed by Supreme Court only, right? That how day-to-day functions would go on in the court, what would be the different formalities involved in the court. All these the courts themselves can make the laws. Okay, that's nothing but judicial legislation, and all different high courts are having their different judicial legislations applicable as well. Okay, if you visit any high court's website, there you would get all these different judicial legislations. You would get to see it. That helps them in their day-to-day functioning. Okay, is it clear?
Yes, ma'am. Basically, it says that we don't need to go for like parliament for everything.
Yes.
We can just make edit, no, ma'am?
Correct. For every single thing, you need not bother the parliament. Okay, maybe for establishment of a court, you can bother, but how day-to-day functions would go on and all, there you need not bother the parliament.
Okay.
Like during COVID, online hearings happened, right? Everything was online. So how that online thing would happen, their courts were only taking decisions. Okay, that this we need to do, that we need to do, this is how we can implement. That's nothing but they were only taking care of it, judicial legislation.
Okay.
Then we have legislation under local self-government. Okay, what is local? As in it's not center or state government, but local governments. Okay, local governments, they are taking care of their own things like panchayats, we have municipalities. These are called as local self-government. That certain matters are there which municipalities are taking care of. Certain matters panchayats are taking care of. So they are also given that much of powers so that they can take care of themselves as self-government. They are not dependent on parliament for everything. Whatever things are entrusted to them, they are able to take care of it. Like municipalities would take care of maybe cleanliness of the that municipal area, right? That's nothing but a power given to them. So they will make laws, rules relating to that within their area. Like giving vaccines to stray dogs or some operations would be done. All those are taken care of by municipalities, right? So they might pass some rules or regulations relating to it.
Ma'am, one example, one question, ma'am. If Supreme Court's order is there, ma'am, like pending until the further notice, everyone should follow this. Does it go under order, ma'am?
The Supreme Court's order is pending.
Like the case is pending, ma'am. The last hearing says that this should be followed until further notice.
Yeah.
Some rule should be followed until further notice. That rule becomes a rule, no, ma'am? Which is pending with
that usually becomes binding on the parties only. Like whatever orders court pass, right, in between the case, that usually is binding on the disputing parties only, not like in general it becomes binding. Or sometimes if there is like a controversy on a legal question and court says this is what is to be followed, then yes, those orders also can be considered as law. So when we say law, it's not just legislation. A lot of other things are included. Orders can also be included there.
Like for example, ma'am, hijab ban issue, and now let's not take that decision of Karnataka. Supreme Court says that not to a job until the further notice. That's kind of a rule, no, ma'am?
Yes,
That
that's
not
kind
to
of
wear.
a rule. Correct. That's kind of a rule. In fact, that is what happened in Karnataka also. Before the High Court decided the matter, some department of the government said that let's, like maintain peace because schools and colleges were shut down for 3-4 days. Let's not hamper education for this matter, but rather let's just, like follow the procedure until High Court decides on the matter. That's also nothing but what should be obeyed because a certain authority has said that.
Okay. Okay, ma'am. Got it.
Yeah. Legislation under local self-government. So local self-government bodies are offered powers to make bylaws. We call it as bylaws because these are applicable on those specific bodies only. Like if a municipal corporation passes a law, it's applicable in that municipal area. So we call it as a bylaw. If university passes a legislation that's binding on students of that university, we call it as bylaws. Okay.
Okay.
So local self-government bodies are also offered powers to make bylaws concerning their neighborhood matters. Bylaws made by neighborhood body works in its individual area only. For example, municipal corporations, municipal boards, Jilla Parishads, panchayats, whatever laws they pass, it's binding on that area only. Okay, like a municipal corporation saying that throwing garbage on the road, you will be fined 500 rupees. Or they might say that, okay, if you are seeing anybody throwing garbage, you can click a picture of that person and send it to us, and we will take action against that person and we will reward you. That's also nothing but a bylaw that's applicable, that based on your picture, action would be taken on that person. Right? Municipal this might say that plastic is banned from this date, it should not be used. All of that is nothing but bylaws passed by them. So it is legislation under local self-government.
Okay.
Laws made by such bodies come under municipal legislation, for example, town planning, etc. Town planning might say that, okay, this certain thing needs to be taken permission, this certain thing needs this kind of a registration. A lot of procedures are there. Okay, for construction, maybe these are guidelines you need to follow. These are permissions, approvals you need to take. Whatever is mentioned, it's applicable in that specific area.
Okay.
So this is nothing but legislation under local self-government. Then we have something called as autonomous legislation. You might have heard of autonomous universities. Have you heard of it?
Yes, ma'am. Like Christ University.
Yes, they are autonomous universities,
Yes.
as in they are running themselves, right? So in exceptional cases, legislative powers of the state are delegated to certain entities or bodies like universities, companies, corporations, etc., to make bylaws for regulating their business. It is also known as autonomous legislation. So what all rules, regulations will be followed in that university, they will decide it themselves, they will take care of it themselves. That's applicable to them. What all would be the policies in a company, they will decide it. Working time, whether 3 shift would be allowed, whether 1 shift, night shift allowed, not allowed, all of that companies would decide. That's nothing but their own things that they would decide. Corporation, different organizations may also have their own bylaws, right? All of these are nothing but which helps them to take care of their work, right? To take care of their business. These are nothing but autonomous legislations.
Okay.
Okay, like what would be the procedure for taking admission in Christ University? Whether it would be one interview or written test would be there, or what would be there, what not would be there, they are deciding it. Right? So that's nothing but a decision that they have taken regarding admissions, and it's applicable to them. That is autonomous legislation.
Okay.
So apart from existence of supreme legislation, it is imperative to also place due consideration to subordinate legislation. Subordinate legislations are also important, as the parliament cannot overlook and regulate the smallest function of the state. They delegate some of their powers to all these different bodies. Everything parliament cannot take care of. And this ensures that day-to-day affairs of the state are undertaken smoothly without any sort of inconvenience. We don't need to wait forever for a certain law to be passed. Quickly decisions can be taken by these bodies as well. Okay, is it clear? Any point, doubt?
No, ma'am, I don't.
Okay, so supreme and subordinate we have. Within subordinate, we have different classifications, 5 different types of legislations that we see. Next we have is construction. Okay, we already started what is interpretation. Another concept that we have is construction. Now, what is construction? Construction is the process of drawing conclusions. Okay, what is interpretation? Interpretation is understanding. Yeah, what is it? Interpretation of statute. Interpretation is like we try to understand, right? We try to interpret meaning of a certain word. But construction is like we try to derive conclusions. Not just we want to get a meaning, but we want to. Interpretation is nothing but we try to derive meaning, right? What does this certain word mean? Construction is like we want to get a conclusion out of this entire thing, what we are reading. We want to get a conclusion. Okay, so it is nothing but drawing conclusion of the subject which are beyond direct expression of the text. When you read the text, you might feel something. Another text you are reading, you might feel something. So you want to derive a conclusion. What is it, that ultimate purpose of it? Like while reading an article, we want to know, right? Like what is the main purpose? Or maybe somebody watched a movie. You can ask, right, what is this movie all about? So they might tell you that, okay, this movie is all about this certain thing. That means might be this movie may be of 2 hours, but they just told you in summary what is the conclusion, right? What is it all about? Same ways in construction, we try to derive conclusions of the subject which are beyond direct expression of the text. The court draw findings after analyzing the meaning of the words used in text or the statute. We would see what is being used, how it is being used, and after that we would try to derive a meaning, we would try to analyze it. When there are certain set of facts pending before the court and construction is applicable of the conclusion of this fact. In order to derive some conclusion, in order to derive some meaning, we need to conclude it, right? After analyzing meaning of all these different words and everything, we need to derive some conclusion. What is it that this legislation is providing, or what is it that this legislation is talking about? Okay, now what are the differences between interpretation and construction? In law, interpretation refers to exposing the true sense of the provision of a statute and to understand the exact meaning of the words used in the text. Like if there are some words which are confusing, we try to know what is this word used for. When we get the word posting, is it posting in relation to appointment and promotion, or is it also including posting in terms of transfer without a promotion, right? We try to get the meaning out of this certain provision. But what is construction? It refers to drawing conclusions from the written text which are beyond outright expression of legal text. There we want to get a conclusion out of this entire thing, right? What might be the purpose of this entire legislation? In what ways it would be applicable, on whom it would be applicable? We want to derive a conclusion for that. So we want to get some meanings out of those unclear provisions or unclear phrases. Interpretation refers to the linguistic meaning of the legal text. The purpose of construction is to determine legal effect of words and the written text of the statute. So here we just want to know where is it applicable, on whom is it applicable, what would happen if it is applicable on these persons, right? In case of construction, we try to analyze all those different things and finally we try to like conclude it, right? We try to get some meaning out of it. But in interpretation, it just gets some meaning out of the words which are not clear. In case of interpretation, where the simple meaning of the text is to be adopted and the concept of interpretation is being referred to. In case of construction, where the literal meaning of the legal text results in ambiguity, then the concept of construction is adopted. How can we derive a meaning? Okay, if some problems are there, some confusion is there also, which meaning can we adopt? How can we apply it? It's like an overall thing that we have in case of construction. We try to get some meaning. We try to see, is it applicable here? Is it not applicable? If it's applicable, how it would be applicable? We try to get all those details from here. Okay. So in case of construction, we have different rules. First one is harmonious construction. So in case of harmonious construction, it is construction by which harmony or oneness amongst various provisions of an enactment is arrived. That if there is a legislation having two different provisions, if there are 2-3 different legislations having different provisions, what is going to be applicable and how is it going to be applicable? We try to derive some meaning wherein it's not conflicting with the other provisions. When the words of statutory provision bear more than one meaning and there is a doubt as to which meaning should prevail, then such meaning should be adopted by which the words best harmonize with the subject and subject of enactment. So we try to see that, okay, this certain word is very confusing. We try to say, what is this legislation all about? Okay, if this legislation is talking about maybe welfare of workers, then we would try to understand this word in that same direction only. Okay, we don't just try to see meaning of one certain word, but we want to see overall what is this legislation all about, for what purpose it was introduced, and then we try to give it a meaning. Okay, that is nothing but construction. There was this case, Qureshi versus State of Bihar, where Supreme Court held that the state should implement directive principles in a way so as that it will not interfere with fundamental rights. Directive principles and fundamental rights both are given in one single document only, Constitution of India. Fundamental rights are already binding on us. Directive principles are some directions given to the government. So from directive principles, okay, from directive principles, if you want to put anything in fundamental rights, you need to see that you are doing it in such a way that directive principles, okay, implement the directive principles in a way that it would not interfere with fundamental rights. It should not happen that in the name of implementing a directive principle, you are giving a fundamental right which is conflicting with the already existing ones. Okay, you should provide it in such a way that there is harmonious construction between these two provisions of one single document, that is Constitution of India. Okay, so there may be in one legislation, there are 2 more provisions, there might be multiple legislations talking about certain thing. We need to see that everything comes together and provides us a reason or provides us the concept altogether. Next we have is beneficial construction, which involves giving the widest meaning possible to the statutes. Once we look at only the words, we might get some meaning. Once we read it in reference to the entire subject, we might get some other meaning. So our main purpose should be to give widest meaning, as widest as possible meaning to the statutes. When there are 2 or more possible ways of understanding a section or a word, the meaning which gives relief and protects the benefit which are purported to be given under the legislation should be chosen. Mostly we see, okay, there is another type of legislation which we have is welfare legislation. Okay, as in a legislation which is introduced only for the purpose of welfare of someone, only to provide some rights, some relief to a person. These are called as welfare legislations. Okay, so if there is a welfare legislation, what we need to see is, we need to see that is it actually serving welfare to that particular person? Is it actually being beneficial to that person? With what object was this legislation introduced? We need to see that part. Okay, so this beneficial construction rule was applied in this case as Shah versus Presiding Officer Labor Code. There is a legislation called Maternity Benefit Act 1961, under which for maternity, right? 6 months leave is been given. That 6 months you need not work, you need not come to office, you need not work, but still you would get salary for those 6 months. Okay, that is nothing but maternity leave. Now, in this case, what happened, right? There was an employee of a certain factory, and she claimed for maternity leave, which is for like 6 months, right? So what happened is it was said that, okay, fine, you need not come to office and you would be getting salary. So otherwise, when you were not pregnant, how many days were you coming to office? You were not coming on Sundays, right? Remaining days only you were coming. So while giving the wages, right, how much money the person should be getting, ideally it's that whatever is your basic salary, that same thing you should be getting, minus the extra earning that you are getting because of extra work or something, whatever is your basic salary that you should be getting. But in this particular case, the factory, right, they wanted to interpret maternity benefit in such a way that they said that, okay, how many ever days you are otherwise coming, minus the Sundays, for that many days only you would be getting the payment. That means it would be lesser than the salary, right? So in this particular case, beneficial construction rule was applied, and it was seen that what was the purpose of this legislation after all? It was to provide benefit to women who are getting like who are delivering a baby, right? So that purpose has to be served. We should not interpret it in such a way that, okay, how many days you would have otherwise been working for those many days. No, it tries to provide that benefit. That means whatever is the regular basic salary, that particular salary the person should be getting. That is nothing but beneficial construction, because this entire legislation was introduced for somebody's benefit. So we need to see, is that person actually getting a benefit or not? Okay. And when we talk about this legislation, it is also one of the legislations which is introduced in terms of the directive that is given under Article 42, that states should try to provide just and human condition of work and maternity relief. Working conditions should be proper. It should not happen that because of economic necessity, people are forced to work in such kind of a condition which is not suitable for them. That should not happen. So in terms of that, we need to get meaning or derive a meaning out of it. Okay, then we have reasonable construction. Reasonable construction, it is nothing but based on interpretation of statute is made in, it should be done in a meaningful and sensible manner. Reasonable, as in some reasoning has to be there. When we are interpreting a certain provision, meaning has to be assigned. It should not happen that just for the purpose of interpreting, we are simply giving meaning to each of the words and getting something, right? It should provide a meaning, and everything should match with the other things. A reasoning should be there. If a statute is having two interpretations, when we try to understand it in a normal, ordinary way, there are two ways to understand this particular provision. One is completely vague and absurd, and other one is perfectly making sense. Then the meaningful interpretation would be used. How we would construct this particular provision, where we are getting more meaning of it, that particular provision we would use, not where we are simply adding meaning to each and every word and we are getting some kind of a construction. That rule would not apply, but where it is serving some purpose, where it is making sense, that particular construction rule would be applicable. That particular way of construction will be applicable for it. There was this case where court stated that if language of a statute leads to, it's not very clear, okay, that if you try to interpret it in that given certain format, only it would lead to injustice. In such a case, construction may be put upon it, which modifies the meaning of the words used in the statute. We need to try to interpret it, or we need to try to derive meaning in such a way that it is making sense. It's not that we are simply adding meaning to the words and whatever we are deriving, we are simply accepting. That should not happen. Okay, entire thing has to give some valid, meaningful understanding of the concept altogether. Okay. So whenever a legislation is introduced, there would be some purpose for which it has been introduced. So while we are using it, while we are interpreting it, there also we need to ensure that it actually is serving the purpose. For that, we have all these different rules of interpretation, construction, all of that we have. So fine, then I will be sharing this unit 4 one more time with you, okay? With the questions we discussed yesterday as well as today. So you can go through these ones as well, okay? Okay, so yesterday I mentioned, right, that there is something called as secondary rules of interpretation. Primary rules we have seen, there is something called as secondary rules as well. So what are these secondary rules? We will see.
Ma'am, primary rules are like golden rule, lateral rule, and what to say? Golden,
mischief,
lateral, and
harmonious.
mischief rule. Sorry.
Yeah, mischief rule, harmonious construction. Beneficial is also there, but these 4 are like very important. Okay, if you want, you can put beneficial rule also here, but these 4 are very important that you need to mention when we talk about primary rules. Then we have secondary rules. So other than primary rules, there are some other ways also which are applied in interpretation of statute. So what are these secondary rules? First of all, nociter associs, existum generis, redendo singula singulis. Okay, so what is meaning of these words? First of all, nociter associs. Nociter associs is a Latin term which means associated words. The meaning of unclear words or phrases is to be determined or interpreted on the basis of its context and the words and phrases surrounding it. Has it ever happened to you, somebody asked you meaning of a certain word? Like if I randomly ask you that, what does admission mean? Okay, so what answer you would give? You might feel like, okay, admission means what? Admission are you talking about? Are you talking about admission in a college or university? Are you talking about admission in a hospital or admission in a school? What is, in what context you are asking, right? So when somebody asks us meaning of a certain word, sometimes we don't straight away answer them, right? We rather try to ask them that in what context are you asking? Or if somebody says that what is meaning of this word, we might ask them, okay, what is the sentence where you have got that word? Ever have you come across this kind of a situation?
One word, two different meanings, ma'am.
Yeah, one word might have 2 different meanings, right? Like I might ask you that, okay, what this certain word means in Hindi? And you might be like, okay, where have you got it? What is the sentence? What is the context? Like we need to know what, in what context you are asking about it, right? One word might have multiple meanings because, right? So this is nothing but what is nocister associs, that it might happen that one word might be having different meanings. We need to know in what context you are talking about so that we can tell you properly. Okay, like if I ask you, okay, what is the admission process? You will ask me, what admission process are you talking about? Admission in LLB, admission in school, admission in a hospital? What admission are you talking about? Right? You cannot tell me what is the admission process unless and until I specify you what admission I'm talking about, right? And you will know about it only when I tell you the proper statement that what is the process of admission in KSLU. Then only you will be able to tell me, right? Otherwise it becomes confusing. So how do we know what admission I'm talking about? You need to see what other phrases are surrounding it. You need to know the context. If I tell you what is the admission process, you cannot answer. If I ask you what is the admission process for LLB in KSLU, you will be able to answer me, right? That's nothing but what is nocister associs. We need to see the surrounding words, in what context you are asking about it. Okay, so nocitor means to know and socis means in association. The importance of this rule is that it aims to interpret by reading whole statute. It's not that one single word we will pick from somewhere and try to interpret it. We need to understand it in the whole context. It does not emphasize one particular word, but it tends to interpret the word by looking into its preceding and succeeding words. We don't try to give meaning to a certain word just randomly. We try to see what is previously said, what is after it said. Like we need to try to read the entire sentence or maybe entire provision. After that only we try to give meaning to it. The words understood in a cognitive sense and intention of the legislation can be easily understood. We need to know what is the intention of legislation. We need to properly apply our mind, read the entire sentence, and then only we should give meaning. Not like if I ask you what is admission process, you would randomly answer. You need to know what admission I am talking about, then only you will answer. That's nothing but nociter resources. It was applied in this case, State of Assam versus R. Muhammad. What happened here is Supreme Court made use of this rule to arrive at the meaning of the word posting. Now, if I ask you what is posting, what would you answer? What do you think posting is?
Like a transfer of job, maybe from one place to another, or transfer of like position from a junior to senior, or senior to
Okay.
like
Like
posting
appointing.
job.
Sorry, also?
Appointing. Appointing.
Appointing. Okay, appointing, promotion. Yeah. And anything else?
That's it, ma'am.
Okay. So when I say posting, it might have multiple meanings, right? Posting, when a person
From
gets
one
a
place
new
to
job,
another.
posting after a promotion, right? Or I might say that I'm posting a letter to someone. That's also posting.
Yeah, ma'am.
Right? Posting would have different meanings. Okay. So in this case, the main question was what posting means. Okay. So in this case, this secondary rule was applied, no sister resources, in order to understand meaning of the word posting, which is used in Article 233 clause 1 of the Constitution, which relates to appointment of district judges. Okay, it relates to appointment of district judges of the Constitution. So it held that since the word posting occurs in association with words appointment and promotion, it took its color from them, and so meaning of assignment of an appointee or promoted to a position, and does not mean transfer of a person from one station to another. So when we talk about posting, they said that it means only, we need to understand the context, because we are talking about appointment of district judge, right? So somebody who is promoted as a district judge, that would be included. Somebody who is appointed as a district judge, that would be included. But it would not mean simple transfer of one district judge to another district judge. Okay, so we need to understand the context, because we are talking about appointment of district judge. So when we say appointment, in context of appointment, posting would mean somebody who is appointed, maybe directly by way of examination or by way of promotion. In that sense, we need to understand it. It would not include transfer of one district judge to another place as a district judge, like same level, it would not include it. Is it clear?
Ma'am, can you repeat this, ma'am? I didn't get this.
Posting
This
word, they
case,
had
in
to
this case,
understand the
what was
meaning.
like State Assam versus Muhammad? What was the case, ma'am?
See, this person was like transferred, okay, as a district judge from one district to another district. He was transferred. It was not related to promotion, or he was not as such directly appointed. He was transferred as a district judge from one district to another. So the question was whether this word posting that is used in this article, it means appointment, promotion, or it means transfers also. So court had to understand what posting means in Article 233 of Constitution. So they tried to understand the meaning that, okay, posting is used in relation to appointments. So when we say appointments, it would mean appointment of a person, or maybe promotion of a person as district judge. But it would not mean transfer of persons. Okay, is it clear?
Okay.
See, in these cases, right, whatever you get in interpretation, you need to see how that particular rule was applied. Okay, you need not know what happened in this case. Was the person transferred or not transferred? Those things we are not concerned here. Okay, because we are understanding this case in relation to how these rules were being applied. Okay, so in this case, how it was applied, that we need to know meaning of posting. We will not simply understand it randomly. We will understand it in relation with this word appointment. So what appointment? Posting would mean in relation to appointment, it would mean appointing a person or maybe promotion of a person. That would be meant, but not transfer of a person. Okay, is it clear or confusing?
Like posting means no transfer, appointment or promotion.
Yes.
Yeah.
Not like in general. Okay, for this certain.
No, in law.
Yeah, for this particular article, it would be. Okay, next rule we have is existum generis. Let me give you one example. When you appear for some exams, right, you will get these kind of questions. Can you tell me what will be this in the blank? What you will fill in this blank?
Two, 4, 6, 8, 10, 12.
8 you will fill. Okay. And what about this one?
Is 3 gaps.
Yeah, this is like a blank. What you will fill here? Friday. Correct. So how did you decide that this will be 8 and this will be Friday only?
It could be.
You are right. This is 8 and this is Friday only. But how did you decide? How did you come to that conclusion?
Ma'am, because of
Like,
consecutive.
Yes.
The width of the each class is like
the difference is constant, ma'am.
Correct. That is nothing but what existum generis is. Okay, you also applied that same rule only. So what it says is, we need to see what is common in all these. What you saw that, okay, fine. One gap is there. That here also same thing has happened. That's nothing but existum generis. Okay, what it says, of the same kind. It has to be same. Okay, you also saw that, okay, 2, then 4, then 6, then it should be 8 only. After that, 10 and 12. You saw what is similarity in it. Right? So generally, the words should be given their natural meaning unless it requires special meaning based on the context. It is fine if natural meaning is making sense, if you are able to understand the concept, if it is giving justice, no problem there. Apply the natural meaning. But sometimes it might happen that words are very much complicated, right? We are confused what this certain word means and what not. Okay, in such situations, we can apply this rule. Okay, when general words follow yeah, sorry.
No, ma'am, sorry. I talked to my mother once.
So when general words follow specific words that are distinct in nature, the general word should be given the specific meaning to it. If you are able to understand with general meaning, it's fine. If not, what we will do? So court will interpret such general words to follow specific words in a restricted way. It will be based on the facts and circumstances of the case, which may change case from case to case. The legislative intent on principle of existum generis is, if the general words to be used in the restricted sense, that means those words will be having a special meaning to it. Else, why would they even use specific words? So what a certain word means, we have confusion over there. To understand it, we are applying this rule. Like there was a case called University of Madras versus Santabai. Very important case. You will study it in Constitution also. Okay,
yes,
so,
ma'am. I'll listen to this case. I don't know what basically.
Okay. Article. Okay, so there is one provision, very important provision under Constitution. It is called as Article 12. Okay, it provides for a definition of the term state. Okay, so in general, what happens when I say state? What state means? State of Karnataka, state of Maharashtra, Madhya Pradesh, like
Yes,
that
ma'am.
we use the word state. right? But for the purpose of two parts under Constitution, Part 3 and Part 4, this word state is having a wider meaning. Okay, it's not just state of Karnataka, state of Bihar, but it's having a wider meaning. What wider meaning it is having? It would include parliament also. It would include legislature also. Plus, it would include other authorities, okay, other local authorities within the territory of India or under control of India. So it includes a lot of different bodies.
Like whole country, ma'am. State means.
In international law, state means the country, but here it means different departments, different organs of the government, basically. Okay. So now what happened is, when you look at the provision, right, it is a bit confusing because first of all, it says Parliament of India. Okay, it says government and Parliament of India. When we say government, it means executive, legislature, and it means Parliament of India. Fine, it is clear. It means government of the state and legislature of each of the states. Fine, that is also clear. But when we say all local or other authorities within the territory of India or under control of government, what does local and other authorities mean? That was the confusion. Okay, so court had to decide what local and other authorities mean. In this case, University of Madras versus Santabai, court had to decide whether university is included under Article 12 or not. Okay, and court said that we will apply assistum generis. We need to see what is similarity in these things. Okay, when we look at this definition, there are three things given: government and Parliament of India, government and state legislature, and all local and other authorities. So we need to look at the similarities. First of all, it is talking about government and Parliament of India. It's like a sovereign body, right? Same ways it is also saying government and legislature of each of the state. So because this sovereign thing is common, right? Like a government department, it would include government body, it would include. When we talk about local and other authorities, it also should perform some governmental functions. Okay, so university cannot be included under definition of Article 12 because it is not having those similarities with these two provisions. Like that, assistum generis was applied and it was said that university is not included under Article 12. But later on, this decision was changed. Now it is said that universities are also included. But this case is important because assistum generis was applied here. Okay, so assistum generis, they tried to see what is like nature, what is similarity between these three things. If first two are talking about governmental bodies performing governmental functions, third one, other authorities, also should mean something which is performing governmental or sovereign function. Okay, is it clear?
Yes, ma'am. Got it, ma'am. Like similar in nature.
Similar in
Basically,
nature. Yes.
it should be included under that assumption.
Yes.
Generous.
We need to see the similarity in order to understand what a certain provision means.
Okay.
Okay, last one we have is redendo singula singulis. So this is again a Latin term which means by referring each to each. Sometimes it happens, right? We say a sentence wherein we say, we might say that this person, okay, Ram, Rahim, and Kiran got 5, 20 rupees respectively. Can you tell me who got how much rupees? Ram, Rahim, and Kiran, three persons are there. Who got how much rupees?
Ram 5, Rahim 10, and Kiran 20.
How you got to know? Because I have used the word
Because
respectively.
and the name is like order, and money is also in order, first 2, 3, 1, 2, 3.
Correct. When we use the word respectively, it makes it very clear that, okay, how much who got. Sometimes this might not be there. What we will do in that situation, that's what this rule is all about. Okay, it says each to each, referring each phrase or expression to its corresponding object we need to understand. Okay, in simple words, redendo singula singulis means when list of words has a modifying phrase at the end the phrase refers only to the last. So how we will understand it? There was this case where this rule was applied. Okay, what happened here is they had to understand a certain provision, that is Article 304 of the Constitution. In that provision, it says, provided that no bill or amendment, okay, no bill or amendment for the purpose of clause B shall be introduced or moved in the legislature of a state without previous sanction of the president. Now here, respectively word is not being used. So we have two terms here, bill or amendment, introduced or moved. So it had to be understood that bill introduced refers to bill, or introduced refers to amendment, or moved refers to bill, or it refers to amendment, or is it that it can be used for both? Okay, that was the confusion. How we need to understand it, because here respectively is not being used, that bills or amendments introduced or moved respectively not being used. So we had to understand it, what introduced stand for and what moved we can relate to. Okay, so in this case it was held that the word introduced applies to bill and moved applies to amendment. Like we need to understand each with each. First of all, we have bill, so we need to understand it in context of introduced. So introduced bill or moved amendment, because that is used second. Okay, each phrase we need to understand for the remaining one. First bill is used, so introduced bill. Second moved is used, so moved amendment. Is it clear?
Yes, ma'am. Like we should find the similarities of words. Basically, if two words are having like 1 and 2, and the other thing has like 3 and 4, like comparing, ma'am. Basically,
like order, in order we need to understand.
yeah, in order.
Okay, so these are the secondary rules of interpretation.
Ma'am, it's like redundo singula singulis means like understanding the words similarities, no, ma'am. Like in order to keep
order, you can say each phrase with each
respectively.
Yeah.
If it's not mentioned also respectively, each
Yes.
phrase goes to each phrase orderly.
Yes, in that order only we can understand it.
Okay, ma'am. Got it, ma'am.
Okay, so these secondary rules or primary rules, all these are important because statute might not always be clear, explicit, and unambiguous. A lot of confusions are there when we read a certain provision. So that's how rules help us to get clear meaning out of the complicated words. In such cases, it is essential for courts to determine a clear and explicit meaning of the words. When there are doubts or when certain words are not clear, it's duty of the courts that they clarify those things, they give proper meaning to the words. So different rules are becoming very important in that context. Okay, so nocitur associis, it means to know in association. You cannot give meaning to a certain word just like that. You need to understand the context. In what context a certain word is being used, like that you can give proper meaning. Assistum generis means you find out the similarity, what is common that is going on, that you need to understand. Redundo singula singulis, it's like an order, you need to understand it. Okay.
Ma'am, this ejusdem generis, one more time, ma'am, like small.
Assistum generis means we try to find out the similarity. Like you said, okay, fine. After 2, 4, 6, what is the
Okay, ma'am,
similarity?
got it.
One gap, right? We try to find the similarity. So in this case, it was said that what is similarity? Other two bodies are governmental bodies performing sovereign functions. So other authorities also should be governmental bodies performing sovereign function only, like panchayat and all, municipalities and all, but not an university. Like that it was understood.
Okay.
Okay, so I'll share this document with you. You can go through this part. Unit 4 is over. Okay. Unit 2, I will see if something more is there. I will try to add it. And tomorrow we can discuss it. Otherwise, Unit 4, I'll share the document one more time. You can go through these parts. Okay.
Okay, ma'am. Thank you.
Yeah. Okay. So there was another question, write a short note on law reports. Okay, so there are different types of law reports that we see. Okay, so there was this question, write a short note on law reports. So law reports are published records, Okay, when we say reports, these are published documents. So these are published records of a judicial decision that is cited by lawyers, judges for their use as precedent in subsequent cases. The report of a decision ordinarily contains the title of the case, statement of facts, giving rise to litigation, and history of the court, etc. It also mentions in detail the judgment. Okay, so all those details we get in the law report for different cases, and that is very helpful while citing it for as a precedent, or while arguing in order to strengthen your case. You can make use of it. There are different forms and types of law reports. Okay, first one we have is on the basis of length and language. Full text law reports. So these reports incorporate the entire judgment that has been given by the court, along with a head note which includes summary of the judgment. These reports are often cited in preference to summary reports. So when we talk about full text report, so when we say summary, it's like one person read the entire judgment and he would write a summary maybe in 500 to 1000 pages, wherein a lot of information gets missing, like details of the case, what arguments and all that things get missing because they need to narrow it down. But when we talk about full text law reports, it provides for all the details, entire judgment is there, everything is there. Apart from that, in short, starting, they would mention the judgment summary also, that this is what happened in this particular case, and after that, the entire decision would be there. Like that, details are provided. So if you want to simply understand what this matter is all about, you can read the summary. After that, you can go into the details of it. So full text law reports we have. Also, there are summary reports. Summary reports are those law reports which only include summary of the case as seen in Law Digest. These are also comparatively less formal as compared to full text report, because in full text report, entire judgment exactly it is being provided. But when we talk about summary, it is like very easy to understand, in a very easy to understand language. It is narrated just like a story, that this is what happened, this is how court said, this is what court has given decision. Report
Like Keshavananda Bharati case have more than 1100 pages, ma'am. But summary, like if you found less summary, no, ma'am, like summary, it's very good. It comes under like 40 pages.
Yes. Correct. So even there might be some summaries which are even narrower, which just explains that this is what matter was. These are the things that are being included, right? So depends, summary also, it might be like they try to explain everything, or sometimes it might be like in very short, they just give you an idea about what this case is all about. Okay, so sometimes people find it difficult to understand a certain case, what is the judgment, what it is saying, because judgments are like too long. So in such cases, you can first read the summary report, and after that you go into the detailing. There it becomes easier to understand. That's why sometimes you would see full text law reports, it would contain a summary, after that only details are provided. So that before going into the details, you have an idea what this case is all about, and you don't get confused altogether. Okay, then reports may also be classified on the basis of whether they are official or privately published. So there are official reports and non-official reports. Official reports are those reports which are published by authorities. They are not very popular even today, since they are updated slowly and often quite expensive. One such official law report in India is Indian law reports. We see Supreme Court cases, SCC, right? So Supreme Court reporter. So there may be something which the court publishes, which is like coming from the authorities. That's nothing but official report. And there may be something which is coming from a publisher like AIR, All India Reporter, right? It might be coming from a different publisher. When we talk about publishers, because they need to publish it quickly so that more and more people buy from them, they publish it quickly. But authorities, it does not matter that much because they are having other work also. They are not simply a publisher, so its process is usually a bit slower. They take a little time to publish it as compared to regular publishers that we have for law reports. Okay, non-official reports, they are privately published law reports. These days, non-official reports are often favored over official reports due to speedy publication. Quickly they publish because publication is what their main area of work is. However, since they are privately published, they may charge a high fee for providing their services. Moreover, non-official reports tend to be repetitive. That is, they may undermine the purpose of law report, which is to provide information on new precedent. Sometimes you might see that, okay, they are, like publishing the information. Some things might be repetitive or something like that also, because they focus on publishing it quickly to make it available for the public. Okay, so official is something which is coming from the authorities or coming from the department itself. Non-official is something which is coming from outside publishers.
Ma'am, but like importance should be given more for official reports, ma'am, or private?
It depends
Like-
on like what you want to purchase actually, because ultimately the same judgment only would be provided. So while buying, people would prefer the ones which are easily available. Like if I want to refer 2022 cases, I would be waiting for it, right? That who is publishing, whoever is publishing first, I would prefer that publisher's report only, because I need to quickly refer to those cases. So based on that, usually preference is fixed. That's why we see non-officials are more preferred. You would see in your college library and all, non-official reports would be preferred over there.
Okay, ma'am. Okay, got it.
Okay, on the basis of geographical context, we have all India reports. So these reports are official or non-official, accumulate and publish precedents from across the states. Such reports will contain precedents set by Supreme Court, High Court of Madras or High Court of Maharashtra and so on. All India reports we see for different places also. All India report is an example of non-official or non-official all India report, while Indian law reports would be an example of official law reports. So all India law reports would be the non-official covering all the different courts, but Indian law reports is official one publishing the cases of Supreme Court. Then we have state specific reports also, because high courts, for high courts, right, we have state specific reports also. That's why we are saying based on geography, this classification is. These reports are confined to a particular state only. They publish precedents set only by that particular state's high court. For example, Allahabad Weekly Reporter, it's non-official. ILR Patna, it is official. There are also, okay, Indian Law Report Patna, it is official. There are also certain special law reports which are published keeping in mind particular legal field or aspect. These law reports accumulate information regarding one particular issue or one particular field, like labor law, company law, etc. Okay, same ways you would see in income tax reports, labor law journal. So if you are studying one particular area, maybe you are looking for labor law cases, maybe you are specialized in tax, there you can only purchase these reports. Okay, so if you see one office which is dealing with income tax, probably they would subscribe for these reporters. Okay, if there is one organization working on labor law, they would subscribe for this one.
Okay.
Okay, so like that we have different types of law reports that are available.